The case for those who are opposed to this change seems to include the suggestion. Would you have a look at policy 8? The local authority decisions affecting urban are responsive to plan changes. Now they refer to that. What the opponents appear to be saying is that if you look at the regional policy statement, it says shall give effect to, right? And then when you're looking at this, they're saying, well, this is a low order really when you're talking up here about urban environments being responsive to plan changes. It doesn't say you must.
It doesn't.
It doesn't say you must have development capacity available for development capacity available, and that is in policy 8. Does it?
No, so the requirement to actually have at least sufficient development capacity, that requirement stems both from section 31 of the Act and also for the NPS, which of course essentially gives effect to the Act itself.
Oh, you're talking about the, yes, yeah. Right, okay.
So as I go on to say, so it's not the case for the applicants, and we say this plan change adds significantly to development capacity, and I actually don't think that that's contested in this present case. But we're not saying that that means just because we pass the gateway in policy 8 that you must necessarily approve it, because even if you accept that that it does add significant development capacity, you still have to be convinced that it contributes to a well-functioning urban environment.
Yeah. Well, look, can we just concentrate on development capacity, because what the opponents are saying there is, well, the regional council looked at this matter, I think, starting in about 2019, did it not, with the Our Spaces 2018-2048 Greater Christchurch Settlement Pattern Update. So they're looking at, the regional council was looking at this very issue, wasn't it? But how are we going to, in 2009, how are we going to look after this extra growth? And then I've sort of done a bit of a, I'll try and get this printed out because it may be helpful when we have further discussion about it. But the point about that is that the change which followed that consideration, and I may be entering into your next discussion of the regional policy statement, but the change was approved by the minister and became operative on the 28th of July 2021. So only not even a year ago it became operative. So what the others are saying is, well, look, two things. They're saying, well, it's already been looked at. And it should be looked at on a Greater Christchurch basis anyway. Sorry, I should put the other two, I should put the other way around. The first thing is it should be looked at on a Greater Christchurch basis, and therefore the fact that there may be a shortage for Prebbleton doesn't mean to say that you should necessarily create opportunities in Prebbleton because you're looking at the Greater Christchurch. Now, I hasten to add, and I've made it clear before, these questions don't indicate any view. These are just simply testing matters. So the point is that they are saying, first of all, that you look at it on a Greater Christchurch basis. I think Mr. Langman said that. And secondly, they're saying that it's already been looked at, and as late as the 28th of July 2021, when change 1 became operative, that was the result of that examination, and therefore they're saying, to the extent that there is that I have a discretion in this matter, I should decline to approve this because it needs to be looked at in a wider setting, and it hasn't been. So I just want you to comment on that. I may have put too many things together, but
yes, that's a.
And it may well be, by the way,
in terms of a, sort of kind of work backwards in terms of the processes that and I've sort of touched on those various processes that the regional council and the city council say should be the vehicle for identifying where further growth should take place. And those include, as I said, the embryonic sort of spatial plan process, followed by the review of the RPS, and followed by district plan changes. So there are an awful lot of processes to go through if you follow the path that they recommend that you take. And sort of conservatively, I mean, we know how the system works, how long it takes. And conservatively, so that might take, and this is my estimate, that might take sort of 5 or more years.
So you're saying it's not going to affect
But
it?
in terms of I can go on to sort of change one. I can comment on that as well. But in terms of looking at demand from Greater Christchurch's point of view, I'd sort of submit that it's a lot more nuanced than that. One were to look at the words of the national policy statement, and in particular, sir, I'm looking at Objective 3, which talks about enabling. It talks about enabling more people to live in areas where one or more of the following apply, and sort of.
Sorry, which one was that? That's
Objective 3, sir.
Section 3, yeah.
Objective 3, sir. Yeah. And it states where there's a high demand for housing or for business land in the area relative to other areas within the urban environment.
Sorry, just pause there. What is that?
It's Objective 3C, sir.
3 point. So where are we reading from?
I'm reading, sir, from the national policy statement. So can I just actually, if I could go back to the page of my submissions, where it is reproduced. So it's page 7, sir, paragraph 5.1. In Objective 3, so midway down the page, and Objective 3 would be subsection C.
Objective 3, you looking at?
Objective 3, so. So Objective 3 talks about enabling more people to live in areas in the urban environment. Yeah, so one of sort of 3 separate factors. And these are alternative factors to apply. And C states that there is high demand for housing or for business land in the area relative to other areas within the urban environment. So the sufficient, so that the NPS or the position of the parties in opposition that say that planning should be done on a Greater Christchurch, or demand should be looked at from a Greater Christchurch perspective, by setting aside this particular component of the objective, which talks about relative demand. And there's absolutely no doubt, sir, on the evidence that there's an extraordinary high level of demand in the Selwyn district.
Well, pause there, would you? Is policy 8, as you I think you put policy 8 as being the opening the door, so to speak.
Nothing more than that, sir.
Sorry?
Nothing more than that. It opens the door to qualifying plan changes to be tested on the merit.
Well, let's just say for argument's sake that policy 8 didn't exist. If it wasn't there, then there would be a significant difficulty with the regional policy statement with it on. The way that my understanding of the case for the applicant is that the policy that it's saying in policy 8, with the reference to unanticipated by RMA planning documents, means that the door is open. In other words, you don't have to. The concern that there was in relation to the regional policy statement is alleviated by that reference. Is that right or not?
I think so, sir, and I do go on to it in my submissions, but I think the position of the, in fact, it appears evident, the position of the regional council and the city council is that you can open the door, but you must immediately shut it again because of those high limit objectives and policies in the regional policy statement.
Right, sorry, you just carry on. Just carry on.
So there were a number of factors to your question there, one of which, of course, was your reference to change 1 and the fact that, as you say, the council, the regional council of the Greater Christchurch Partnership have looked at this matter, and that's resulted in this sort of identification of the future development areas. There's a couple of points on that, and of course, one of them is purely evidentiary. And that is what Mr. Colgrave and Mr. Sellers have concluded, is that the FDAs actually will not meet the demand. In other words, they're saying, as a matter of calculation, the regional council and the city council have got it hopelessly wrong, and that may be overstating their opinion, but they've certainly got it wrong by a considerable margin.
But are they saying they've got it wrong in relation to Prebbleton, or they got it wrong in relation to Greater Christchurch?
They've certainly, because the plan changes or change 1 introduced FDAs to Waimak and the Selwyn district. But certainly in respect of Selwyn district, which is an area of high demand, the evidence says that it is wrong.
So you're saying that in relation to Selwyn district, which includes Lincoln and Rolleston and Prebbleton, obviously,
yeah,
that analysis that was done, which resulted in map A in its new form, is wrong.
Significantly so.
Thank you.
So the other thing as well, sorry, the other point I made, because it was a composite question, the other point I make is the obligation under the NPS to meet or to provide significant or sufficient capacity. That obligation falls on individual territorial authorities. So that is an argument, sir, that the analysis should be based on demand and supply within the district, which is a sub-market, so, of the Greater Christchurch area.
Thank you. I think we're up to, I've taken you on a ticky tour.
Yes, you have, sir.
But having said that, we're up to, I think, the bottom, chapter 6, aren't we?
And the ticky tours are the enjoyable part of the job. Where was
So
it?
chapter 6 at the bottom of page 9, I think we're
Six.
talking about the.
So just in
regional
terms
policy
of, you will be familiar with that,
Yeah.
inserted into the OPS by Minister Riley, it's the 5.8 over the page, and it's written with a clear focus on recovery and rebuilding of Greater Christchurch after the earthquakes. With the recovery period, within the recovery period of 2013-2028, a strong focus on efficient recovery, relocation and business growth, and where that would take place is evident. A key concept of certainty is also apparent. in that certainly the future development would lead to efficient investment decision by infrastructure providers and developers. While this was vital at the relevant time, things have certainly moved on from the time of recovery and now, so it's quite clearly a time of growth. And as the evidence of Mr. Sellers and Mr. Colgrave illustrate, nowhere is this as a growth more evident than in the Selwyn district, which faces an ongoing sustained high level of demand for housing. Post 2013, the only amendment of present relevance to Chapter 6 was Change 1, initially prepared under the previous NPS UD 2016, and then finalised under the later 2020 version. And so the plan Change 1 included targets for housing development capacity in Greater Christchurch for the period 2018 to 2048. And it also identified the FTAs that may be rezoned if certain criteria are met. And that's by a new policy that was introduced into the regional policy statement. But as the evidence of Mr. Colgrave demonstrates, development capacity in the district is chronically understated when compared to forecast demand. Mr. Colgrave confirms that this undersupply is not remedied by the FTAs, which are not considered as plan-enabled capacity by the NPS, even if there were both the RPS and indeed the subordinate district plan, which parrots the RPS in terms of the avoidance provisions, still fail, in Mr. Colgrave's opinion, to at all times provide at least sufficient development capacity to meet expected demand over the short, medium, and long term. As a further point, sir, the RPS does not include, as required by the NPS, criteria on significant development capacity, and that's now 18 months since the NPS was gazetted on board. And objectively regarded, the lack of any obvious progress on this matter is difficult to justify.
Just pausing there, because it's a convenient time to discuss it. My understanding of the case for the Regional Council and the City Council is that, in fact, proposed change number 1 as approved by the Minister and coming into force on the 28th of July 2021 was a response to the National Policy Statement.
It's quite clear.
In other words, they did have that in mind. That's what my understanding.
Yes, I appreciate that, sir, but it's quite clear from the documents supporting the Minister's decision. In fact, this is guidance from the Regional Policy, Regional Council itself to the Minister. It was quite clear that Change 1 was a partial response only.
Partial response.
A partial response.
Where's that? Just sorry, just pause there.
I think I'm going to have to sort of provide that.
I'm very comfortable with the idea that you've got a right to reply anyway. I think that's. Could you just bring that a bit closer to you, so I can? Yeah, let's just bring it a bit closer to you.
Are you having difficulties, sir?
No, no. Well, just you're speaking quietly, but that's all right. What I can hear. So. It was only a partial response. I think I would like to know what the evidence of it being a partial response is.
Indeed, sir, and I'm very happy to sort of provide more details, including copies of the relevant documents. But the process was this, is that Change 1 was notified for submissions, and there were reports to the Minister after the submissions closed. And that report includes a number of appendices. So where I get that partial response only statement is from one of those appendices, and I can provide those. I can provide more details.
I'll wait there. Thank you. Just carry on. 5.13.
So, but as I said, the significance development criteria are plainly not in the regional policy statement. And that's a requirement of the national policy statement. So if I can take you back, sir. Although in the present case, I don't necessarily consider it to be a significant issue as I go on to, because I think
just carry on.
it's conceded, yeah. It is conceded by the regional council that this provides significant development capacity. But so the overall submission, sir, of 513 is that the regional policy statement does not give effect to the NPS.
So you say that the regional council accepts that there's not sufficient development capacity?
So, well, that's not what Mr. Langman accepts.
This is pretty important.
It is pretty important, sir. And Mr. Langman has got no technical evidence to support that opinion. And so, in that respect, if there's a contest between the opinion of the experts, one has to look at the opinions of Mr. Sellers and Mr. Colgrave, who are the experts qualified to give opinion on supplying.
No, I know that. I've heard Mr. Sellers, I specifically asked him about the choice issue, etc. But you're saying that the regional council, I understand you, the regional council accepts that there's not sufficient capacity. My question is, well, where did they do that?
No, they don't accept. They say that change provides. I mean, that's explicit from Mr. Langman.
That's what I understood their position.
Yes. And we say, of course, sir, that they're wrong.
Yes, okay.
Excuse me. If you have a microphone a bit closer.
Yeah, please don't hesitate to say when you can't hear. There's nothing worse than sitting in the back, you can't hear anything. Just try that, just have a test run.
Thank you. At 513,
You hear that?
513, we also say that the operative cell district plan, which incorporates the higher limit approach to the RPS, and therefore does not have sufficient shown land to meet demand. And 6.1, for present purposes, the critical provisions of Chapter 6 relied upon by the regional and city councils are the objective 6.2.1.3 and the supporting policy 6.3.1. And it's the above avoidance provisions, they remain essentially unchanged since 2013. And collectively, they establish a doctrinaire or hard limited approach which directs the location of future development and the avoidance of development outside of these locations. And the tenor of the evidence from these councils is that the above directive provisions of the RPS must prevail over the NPS. And Mr. Langman is essentially of the view that the enabling of housing capacity should adhere to this entrenched hard limit framework, and that enabling of capacity should essentially be left to an embryonic at best spatial planning process followed by a review of the RPS. And so the question is how that conundrum, or this particular planning conundrum of tension between the NPS and RPS be resolved. So I use to begin with, the RMA provides for a three-tiered planning management system for the management of natural and physical resources. These documents are interlinked and form a hierarchy, dictating which document should give effect to which. The hierarchy of these planning documents is of particular relevance with the plan change application decisions. In hierarchical order, highest to lowest, these documents are first the national policy statements, second regional policy statements, and third district plans. National policy statements are published by central government and put in place to guide decision making by councils under the RMA at national, regional, and district levels. Section 45 of the RMA reads that a national policy statement's purpose is to state objectives and policies for matters of national significance. In the present case, the housing crisis is set in New Zealand. So I'd also go on to say that, and I think this is obvious from the King Salmon decision, which is referred to later, is that national policy statements reflect the government's latest thinking on how the purpose of the Act, which includes sort of providing for social and economic well-being, is actually to be achieved. 6.7, regional and district council planning instruments are required under the RMA to give effect to the national policy statements as the higher ranking planning documents published by central government. And sort of King Salmon states that to give effect to is a strong direction and demonstrates that national policy statements give more than just general guidance to local authorities. And so more than an overall judgment approach is required on implementing the policies of a national policy statement. King Salmon also contains several observations which are relevant to PC 68 as to why decision makers must give effect to national policy statements. These are the hierarchical scheme of the RMA. National policy statements allow central government input into local decisions, and decision makers should not decline to implement aspects of the national policy statement. Where provisions are in conflict between two planning documents, it is important not to conclude too readily that reconciliation cannot be achieved. Finally, the district plan and local council level, the operative district plan, are required to implement the direction by both regional and national level planning documents. Where any change or proposal that be made to district plans, the higher order documents should be considered when deciding on the proposed changes. And again, to state the obvious, the district plan is required by the NPS to at all times meet the demand for housing, and it plainly does not, sir. Where a document or provision published later in time is said to be inconsistent or at odds with the document published earlier, it is logical to assume by the process of a statutory amendment that the intention of the later in time document was to amend the earlier document. I accept, of course, that this particular canon of standard statutory interpretation has been described as being too mechanical, and instead, where there is inconsistency, the proper approach is to determine which is the leading provision.
Let's just pause there, will you?
So I obviously sort of refer to the Court of Appeal decision in the Queen and Tangapura, which is a completely different context, but it's relevant, sir, in terms of...
Just pause. Looking for the statutory provision which says that a local authority must amend its district plan. I thought section 55.
I'm reasonably certain that it would be, in terms of amending district plan, to give effect to national policy statement. Is that the provision we're looking at?
Somewhere it says that you've got to change the plan. Say, in this particular case, the regional to comply with the national policy statement.
Yes, sir. I think that's around section.
Oh, here we are. Sorry,
section 8.
it is section 55.
Is it?
Subsection 2. A local authority must amend a document if a national policy statement directs so. That's right. So it's a question then whether or not there is a direction in the national policy statement that it must include certain etc. So that there's an issue here. When I looked at this, I thought there may be an issue here because there doesn't seem to be any specific direction in the national policy statement.
I would certainly read the objectives and policies and the attendant methods and implementation as giving very, very clear direction to local authorities as to what we need to do to give effect to the NPS.
So I just pause there. So do you say that 55.2, when it talks about a national policy directing the inclusion, do you say there is a direction or do you say there isn't?
There isn't a direction that I'm aware of under 55.2. I mean, that's a simple sort of a general provision.
Sorry, I'll go back to the national policy statement. Which one? Oh. So which one are you referring to in the national policy statement?
Oh, so in terms of directions to the local authorities.
Yes.
Sort of, I think they're, it's particularly the sort of the methods of implementation.
Yes. So let's just have a look at that. So you're saying that read together, part 3 is that direction. Is that right or not? Under section 55, that is a direction that the local authority must, that in this case the regional authority must change its regional plan.
Yes, and how it is to change plans and what actions that regional councils and local authorities must take. Those actions are particularised in the NPS itself.
Yes, but the question is,
it doesn't.
The question is that do you say or do you not say that that is a direction under section 55? Yeah, don't answer if you want to.
No.
Because then the question then, if you look at section 55, it talks about directing a change to, in this case, the regional policy statement. The question is if that doesn't apply and there's no specific reference in the national policy statement to a need to change it. Well, where are you? What happens then? And of course, you're saying your answer to that is, well, is this case that you've referred to, which is to the poorer case, which is to the effect that you still, as a decision maker, I've still got to look at the inconsistency and not necessarily take the view that the change, that one should await a change. That's the point that Paul was making, is it not?
No. So Paul is simply a case of, actually it's quite a complex case, but the extract that I've included there is just simply in respect of that issue of whether or not a later in time instrument.
Oh, it's an interpretation issue.
It's an interpretation issue only. And, sort of the court saying, well, you can't just automatically assume because a particular provision has been inserted into statute, for example, that actually it automatically repeals an earlier provision. So in the present case, we're not talking about the national policy statement necessarily being taken as implied repeal of the regional policy statement, or in particular the avoidance provisions of the regional policy statement. So what Cora says and what I've highlighted in that extract is so that the proper approach is to consider which is the leading provision. Which is the leading provision. And of course, Cora, again, different context, and that was the circumstance where, if I recall correctly, there is a subsection added to, I think it was the Sentencing Act. And it was a question of whether or not that particular subsection that was added sort of widely repealed as sort of a different section, and the court was saying, well, when you look at the question is, like, which is the dominant section? And that's what I say go on to here, sir, at my 6.4, where I say,
I think I meant again, I think I should allow you to carry on, finish this topic, because I've got a few questions about it. Yeah,
it's absolutely fine. So because what I'm saying is that the document at the top of the planning hierarchy, so it's NPS is patently the leading provision, and it's patently the leading provision in terms of addressing this particular issue of national significance, which is the housing crisis. So, and I would say, because it is the leading provision of the dominant planning document, it must be read as providing over inconsistent provisions within a subordinate regional planning document.
Just carry on reading what I think.
Yeah. So I just say that the purpose of focus of the later in time,
Carol?
the 6.5,
Yes.
sorry, I'm repeating myself here, and I do apologise.
No.
It is on addressing that particular issue, the housing crisis, and therefore must be considered the dominant component of the planning framework against which this plan change must be tested. And as outlined above, the NPS specifically sets out what local authorities must do to tackle this issue of national significance, and that includes being responsive to plan changes such as Plan Change 68. And in contrast, the focus or purpose of Chapter 6, it remains predominantly on the recovery and rebuilding of Greater Christchurch, with limited provision for growth out to 2028, drafted onto its framework by means of Change 1. And as summarised above, the NPS contains a range of actions, including long-term planning process, and those are the future development strategies that I pointed to above. And I would submit so that these processes are or should be read as complementary to plan change processes, which inherently provide greater flexibility to urgently respond to the need to enable further housing capacity. The City and Regional Council essentially says that taking a responsive approach means that while you're entitled to open the door to consider the plan change and its merits, ultimately the door must be closed shut because of Objective 6.2.1 and Policy 6.3.1 direct that outcome. And so to put another way, sir, they say that you can have particular regard to unanticipated development that provides significant additional capacity, but you must decline or you must refuse the plan change precisely because it's unanticipated. So respectfully, that's an absurd position to adopt, one which would render totally meaningless Policy 8 in the context of Greater Christchurch, the Selwyn district included. And I refer you, sir, to the recent decision by Commissioner Caldwell, and it's not binding, sir, I would obviously accept that, but he addresses this particular issue of the tension between Policy 8 and the OPS.
I've actually read that, so you don't
Okay. But I would say that his rationale in that particular decision is clear, and that is that the UPS or NPS responsiveness policy has been intentionally included by government in order to allow a pathway for development in areas unanticipated by planning documents. This is in recognition of the social context of the housing crisis, with demand for housing rising and supply tightening. To rigidly apply the avoidance approach in the RPS would prevent local authorities from acting in accordance with the NPS in being responsive to certain plan change proposals. To do so would be out of step with the NPS. Policy 8 is in our submission intended to address the restrictive attitude councils have towards such development proposals, and to apply to exactly the type of changes proposed by the applicant today. thus to avoid sincere consideration of the plan change, as Plan Change 68 on its merits would fundamentally go against the purpose of the NPS.
Just pausing there, we talked about what requirement there is for the Canberra Regional Council to change the regional policy statement to accord with the national policy statement. It seems to me that the only authority which is on point really is King Salmon. In other words, you've got the hierarchical, you've talked about the hierarchical structure, which is, I think, we will understand. But is there anything that are there any statements in that case or any other case which indicate how, in this particular case, the regional council should respond when there is a higher order document that is inconsistent with its lower order document? Is there any cases, are there any statements on that? What should they do?
Beyond the quite clear statements in King Salmon,
Yeah,
I'm,
well, that's what
I'm not aware of any, but of course King Salmon,
yeah.
again, sort of, it's all about the context, and King Salmon was a different context today, because it at the core of King Salmon was the different provisions of the National Coastal Policy Statement, which could be said to sort of pull in different directions. It didn't deal with the case as it is today between inconsistent sort of directions in between a national policy statement and a regional policy statement. Inconsistency between the tiers and the hierarchy.
You think that?
And so, in terms, just on the issue, in terms of extrinsic evidence, in sort of for completeness, we set out some documents relating to the development of the NPS, which we submit are materially relevant, this being the test for extrinsic evidence to the issue of inconsistency between the responsive NPS and the entrenched higher limit approach of the RPS. And sort of we start with that discussion document, and the opening message for the responsible ministers confirms housing and urban development as a priority for the government, and it points to the starting array of indicators that there is a problem, and as a consequence, there is a need for urban land and housing markets to work better and be more competitive by significantly increasing the number of top development opportunities in the market. So I'll let you read through those stuff.
Is that planning for successful cities?
No, so, no, the post, or this would post, is it, oh, sorry, have I got the citation wrong?
Well, I've got a copy of it in front
Oh,
of me.
it is, so
Planning for success.
my apologies.
Well, all I'm doing is want to make sure I get the right document.
Yes, sir, my apologies.
Just carry on.
Again, sort of the emphasis of sort of underline, emphasize some extracts, including sort of the conclusion by the ministers of the need to significantly increase the number and type of development opportunities in the market. And also it's quite explicit in the fact that those development opportunities include allowing growth both up and out. And there's a specific discussion regarding sort of the need for a more responsive planning system in the context of greenfield development. So it's highlighted there, and this is on page 16 of the submissions.
So I'll just read the
Yes.
that summary of the proposal. Yes, thank you. So the rationale, now the rationale.
Yes. I just highlighted the acceptance there that the challenge of the planning system is not responsive enough to changing circumstances or opportunities. A particular reference to the existing urban boundaries or planned release sequence are sometimes defended to encourage a particular urban settlement pattern. Then, over on page 17, sir, I refer to the actual decision of the responsible ministers on the NPS. And in particular, in respect of what is the purpose behind the responsiveness policy. The last paragraph I've underlined, sir, I think it is very instructive, where it says that the responsiveness approach will also address the possibility raised by submitters and the panel for local authorities to entrench hard urban growth boundaries in their RDSs. And they're saying that entrenching those boundaries could undermine the intent of the NPS. And that's because RDSs are not subject to private plan changes under the RMA.
Is relying on the Sky City principle.
Yes, because this is materially relevant, sir.
Yes, I promise, but it's the precursor to the actual.
Well, so you're taking the minister's decision.
Thank you. Just carry on.
So 618, so both the discussion document and the decision itself are explicitly directing that the purpose behind a responsiveness policy is to ensure plan changes, including greenfield, which would add significantly development capacity, must have the ability to be considered on merit. The application cannot be rejected as urged by the City Council and the Regional Council simply because it's said to be inconsistent with their strategic framework. Overall, therefore, we submit that a responsive approach requires you to consider the plan change on its merits, and in doing so, to put to one side the hard limits, urban limits, in Chapter 6. Of course, sir, it's not the applicant's position that the policy 8, responsiveness policy, is a trump card which demands that the application be approved. Rather, the requirement of policy 8, it needs to be considered holistically. And that is, the council need only be responsive for a change proposed would add to development capacity significantly, and it would also contribute to well-functioning urban environments. So 7.1, as noted above, the Regional Council has failed in its requirement to include criteria in the RBS as to what constitutes significant development capacity, according to your able to determine what it might mean. The NPS defines an urban environment as an area of land that is or is intended to be predominantly urban in character was intended to be part of a housing market of at least 10,000 people. The council has previously considered Prebbleton, Lincoln and Wollaston collectively as an urban environment, and of course that meets the 10,000 threshold. But of course an urban area could include the Selwyn district as a whole, and it could include Greater Christchurch as a whole.
So just pausing there, the consideration, they wouldn't qualify individually, but if you add them all up, they would. That's what the position is. In terms of the 10,000.
Yeah, but just in terms of that specific definition of the urban environment in the EPS.
But the point is that that's regarded as a housing, as one housing market. In other words, Lincoln, Prebbleton and Wollaston, because of their proximity to one housing market.
I think it's somewhat of a sort of a moot point in the present case, sir, because while the submission of the regional council on this by 7.3 and the city council, while the submission says that capacity should be assessed against within the context of the Greater Christchurch area, Mr. Langman acknowledges that's at his paragraph 87, and elsewhere indeed a couple of other locations within this evidence that the contribution of housing proposed here in terms of quantum could be considered as substantial. But that concession is a proper concession, sir, given the scale of the development proposed, the evidence of Mr. Colgrave, Mr. Sellers and Mr. Please, all of the opinion that the significant additional capacity threshold is met. And so this is a hardly a surprising conclusion given the scale of the development proposed set against the context of a lack of available sections within Prebbleton and the extent of ongoing demand. But in addition, as noted above, so the applicants are extremely experienced developers and are able to provide capacity at pace. So contributing to a well-functioning environment, and the features of a well-functioning urban environment is set out in policy 1 of the NPS, and these are sort of include but are not limited to urban environments. And sort of I've actually set this out above in full in my submission. So this is essentially paraphrasing their policies, but those are urban environments, well-functioning urban environments are environments that have able a variety of homes that meet the needs and times, type, price and location of different households, enable a variety of sites suitable for different businesses, which is not necessarily relevant here, have good accessibility for all people, including by way of public or active transport, support and limit as much as possible adverse impacts on competitive operation of land and development markets and support reduction in greenhouse gases. So the fact sheet, the Ministry for the Environment fact sheet of well-functioning urban environments advises that local authorities should be proactive in removing barriers that limit social benefits. These benefits include good accessibility to employment, amenity and services. But in terms of A and D above, a poignant observation or submission is that the current urban environment in Selwyn is not a well-functioning urban environment, particularly with respect to its housing market. Indeed, Mr. Sellers described it as the exact opposite, and that is dysfunctional. So if approved, PC 68 would contribute substantially towards a well-functioning urban environment by adding 820 residential dwellings and increasing population ready to support the township's social and economic well-being. It would contribute to the social benefit of Prebbleton by providing homes in an area of high demand and an area with good access to jobs, schooling and amenities. The proposed 820 lots will provide a variety of medium and low density allotments at a minimum of 12 households per hectare. The plan change is expected to provide one-off economic stimulus by creating employment for around 262 people over an approximate 10-year construction period. This equates to income from jobs directly in the pockets of local builders, architects, surveyors, and the families. Economic benefit also trickles to businesses supplying goods for the development, and when the wages and salaries generated by the construction period are spent in the local or regional economy. This increased economic benefit will be seen in Prebbleton and nearby urban areas such as Wollaston and Christchurch. Both demonstrated to be preferred spending hubs for residents in Selwyn. That aside, the site is directly adjacent to the Prebbleton area marked as an identified growth area in our space. The area has already been marked as this area, as in Prebbleton, has been marked as suitable for future development because the Greater Christchurch Council believe Prebbleton has the facilities, amenities, transport links, and ability to undertake further development and growth in population. And Mr. Cleese has provided substantial analysis of the anticipated urban form for Prebbleton. He notes that the site is located in a manner consistent with future growth direction in the most recent strategic planning document undertaken for Prebbleton. And he concludes, and this conclusion Ms. Hart agrees with, that the plan change site is a logical extension to the existing township form. Mr. Langman claims that the plan change does not support a reduction in greenhouse gas emissions. He is critical of the applicants for not providing any quantitative analysis of how the plan change will address this matter, noting, of course, that no such analysis was undertaken by the Regional Council for the future development areas identified in Change 1. When I say that, no such quantitative analysis. Notably, sir, the language of Policy 1E refers to the word support in terms of reductions in greenhouse gas emissions. It does not say, for example, that greenhouse gas emissions are to be avoided or that a reduction of the same must be demonstrated or particularized. Further, looking at the wider context of the objective policies of the NPS, it is noted Objective 3 contemplates the rezoning of areas that are not well serviced by existing or planned public transport. Rezoning is considered appropriate if other factors are at play, including proximity to areas of employment and areas where there's a high demand for housing. Policy 1C refers to accessibility, including by way of public or active transport. Plainly and realistically, sir, the use of private motor vehicles and attendant emissions must be contemplated. In this matter is, of course, referred to in evidence and will be addressed in more detail in the summaries prepared by Mr. Smith and Ms. Hart. Suffice to say, it is their opinion that the location of the plan change, together with measures adopted to support alternative modes of transport, are supportive of a reduction in greenhouse gas emissions. So in terms of the adverse effects relevant to the Council's functions under Section 31, the effects of the proposal have been assessed by experts on behalf of the applicants. They don't need to be addressed here in detail, and rather we simply refer to effects where a sort of legal dimension has been raised and submissions are evidence. The first one is soil productivity, where Mr. Nathamo provides a comprehensive assessment of the productivity of soils within the area. I'm considering whether the plan change may negatively affect the productivity potential of the soils in the area and future rural activities on the site. It is submitted that the costs and practical difficulty in sufficiently irrigating the sites, according to Mr. Nathamo, were too high to render this practical reality. Approving the plan change would not reduce the productivity potential of the area, and it's highly unlikely that anybody in the foreseeable future would be able to utilize the soils for highly productive farming. But in terms of the proposed NPS for highly productive land, referred to in submissions and evidence, it is just that. It's a proposed national policy statement that I understand sort of has been in abeyance for over 3 years. As such, sir, that proposed NPS does not have any legal weight.
Just pause there, would you? Sorry, carry on. Thank you.
So this is the issue of potential reverse sensitivity effects. And notably, these relate to the submissions by Trent's Nursery. And on your map that you've asked that be prepared, that would be submitter number 12. So that's, as you will noted from the submission, that's a wholesale garden market. So if you follow King Drive down to the end, the intersection with Trench Road, and sort of move just one to the right, it's on the south side of Trench Road.
Oh, yes, I'm sorry.
Yes.
Got it, sorry.
You can actually make out, I think that they are sort of a whole host of shade houses or the like on the site.
Right,
But just on, as I noted, 9.6, that reverse sensitivity is a well-established concept in RMA law and has been defined as follows. And I set out that it's a very sort of common definition.
Thank you.
So whether reverse sensitivity is a relevant effect to address is dependent on a number of factors. First, there must be an existing established use which is causing an adverse environmental impact on adjoining land. Secondly, there's an intended or benign use for this adjoining land. And lastly, the benign use may result in restrictions on the existing established use. So examining the first factor above, there's no evidence of anything other than a very minor and occasional effect associated with spray drift from Trent's Nursery. And so therefore, given the negligible level of effects associated with the market gardening operation, it follows the consequences of establishing more intense residential development in proximity to its boundaries is likely to result in complaints and in turn is unlikely to result in restrictions on the incumbent operation. Both Mr. Cleese and Ms. Hart come to essentially this conclusion and are accordingly of the view that reverse sensitivity is not a barrier to approving the plan change. Ms. Hart discusses how the central bulk of the plan change has already been determined appropriate for rural residential development and so should not raise issues with existing land uses surrounding the site. And so more broadly, well, the RMA provides limited protection to incumbent uses through existing use rights. The Act does not include an express principle that new activities must necessarily be curtailed or restricted simply to protect existing established uses. In the present case, while the district plan incorporates some provisions in relation to setbacks from intensive farming uses, these provisions certainly do not extend to the protection of wholesale market gardening operations or low-intensity farming operations.
Thank you. Would it be within my jurisdiction, if contrary to what you're saying, there was a problem, would it be within my jurisdiction to approve the plan subject to conditions which protected, which is protected the submitter or not?
If you find on the evidence, sir, that some mechanism should be incorporated into the planning framework
Yes.
to protect these incumbent uses, then it would be within your jurisdiction.
Sorry, would that
It would be within your jurisdiction. If you are satisfied on the evidence that there is a problem, it would be within your jurisdiction.
Right, well, it's close enough to 11 o'clock. I think we might take a break at this point. Is everybody happy with that? Right, well, we'll take a break for what's the time now? 11 o'clock? So it's a quarter of an hour. So just go
I'm
help yourself to a
almost,
cup
I'm
of tea.
almost finished with the submission. I've only got a few pages more to go, but I'm very happy to take a break now. So,
Well, I think it's just not going to need a rush for this.
No.
Moment.
right.
Yeah, I'll take And a communication been received from Mr. Williamson. 2 of his 3 children have tested positive, and he's symptomatic and has requested a delay of tomorrow. So, because on the premise that he wants to be here, we're just it's been we're checking the position at the moment. But anyway, that is the present position. We're just checking to see whether the other submitters could give their evidence on the basis that he presents this remotely through Zoom or whatever. But I'm not sure whether that'll be acceptable or not. So anyway, I can't take any further at the moment. But that is the position we've reached at the moment. Mr. Williams is not available to attend personally.
Is he able to attend at the time allotted, or is that the issue?
Well, tomorrow, well, he's scheduled.
Was he scheduled to attend in person?
Yes, well, I understand. Yes. It's 10:50 tomorrow. But he was making a combined presentation on behalf of the submitters, and the question is whether or not he can do that remotely or not. I have no view about it at the moment. We're just checking out to see whether the submitters are happy with that or not. So I think let's leave that in the meantime. I think if you just carry on, we'll just reverse sensitivity. We finished that.
We finished that, and we're sort of moving on to sort of like a summary critique of the evidence of Mr. Langman and Mr. Williamson, and that's sort of matters not sort of otherwise addressed in the submissions above. But at 10.1, sort of the general observation that appears from Mr. Langman's evidence that both the regional and the city council are something of a state denial regarding the present housing crisis in Selwyn. In particular, Mr. Langman makes a number of claims entirely unsubstantiated by expert evidence that there is sufficient development capacity to meet the demand in the district. He denies that there has been a growth spirit and says that there is a perception of high demand in the district. And his analysis is we submit directly contradicted by the expert evidence provided by Mr. Sellers and Mr. Colgrave. And Mr. Langman also refers repeatedly to intensification being the preferred method for meeting future demand, and continually seeks to compare greenfield developments such as the present application with opportunities for intensification. And so, with respect, this ignores the simple fact that the national policy statement specifically provides for development both up and out, and intensification and greenfield. Individual plan change applications are not, in my submission, the arena to debate the respective merits of intensification versus greenfield expansion. And on the same issue, Mr. Langman states in a number of places that greenfield expansion will compromise the intensification policies within the RPS and future opportunities for intensification, even if that were a relevant consideration. In order to place any weight on such statements or opinions, supporting technical analysis would be essential, and none, of course, is provided. It appears respectfully that the witnesses of labor are under a blunt impression that each purchaser of a greenfield dwelling is a purchaser lost from an intensified development. And just on that particular point, sir, what Mr. Sellers has said to you earlier today is that there's very clear evidence of a sort of prospective purchasers of land not being able to actually find anything in Wollaston, Prebbleton, etc. And rather than actually going into the city, they're actually moving further afield, like to places like Dartford and Leaston. Notably, sir, the Greater Christchurch Housing Capacity Assessment of July 2021, that's relied sort of elsewhere on Mr. Langman's evidence, suggests that the relationship between infill and greenfield demand is far from being as simple as Mr. Langman appears to portray. And just it talks about the need for further market analysis relationship between greenfield and infill development. And so the market analysis is that Mr. Sellers, he is very, very familiar with the market. And as I said, the reaction of prospective purchasers is to actually move further afield to places like you mentioned, Ashford and Darfield, where land is available to meet their particular needs. In that housing capacity assessment, so I think it refers to like, there's a complex array of factors that go into the decision as to where to purchase. And that to talk about actually design and section price and amenity. But then in terms of the issue of intensification, that talks about a high level of demand within the central city. So intuitively, the conclusion that one can draw is that the level of greenfield growth over the last how many years?
Sorry, the level of what?
The level of greenfield growth in places like the Southern District hasn't actually compromised intensification initiatives or development in the central city, in Greater Christchurch. So 10.5, on the issue of infrastructure, Mr. Langman does not provide any technical support for claims that the cumulative impact of this plan change and others would impact on the ability to service areas already planned for development. In any event, these claims are contradicted by the technical expert evidence on behalf of the applicant and that of Mr. England for the council. Mr. Langman states that approval of proposals such as PC68 are likely to place pressure for further greenfield development on the periphery of Christchurch City and Waimakariri because of the precedent it would set. The simple response is that the courts have repeatedly held that the concept of precedent does not arise in the context of a plan change request. The law is quite clear on that, sir.
Well, I think that's, I was just thinking about that before. It's interesting that you've raised it at that point, because it was something I was thinking about just a few minutes ago. And it must be the argument, a lot of people would look at private plan changes and say, well, why should first be less stressed, if I can put it in those terms? In other words, why should it seems being opportunistic? But of course, the truth of the matter is that the Act actually provides for it. And therefore I don't, that doesn't surprise me that there's that, because the Act provides for land use opportunities for people who want to initiate a private plan change, but they've got to get through all the other hurdles. It's got to be suitable, and it's got to, all the section 75, 74 considerations, etc. So anyway, so just the point is that is not surprising.
So it has to be tested against the objectives of the NPS in terms of particularly a well-functioning environment.
The only point though about that, and I'll come on that in greater detail later, but the only point about that is the argument that there should be deferment, that should be deferred in the particular circumstances of this case, because of steps that have been taken. That's a discretionary matter as far as as to whether I do or do not approve of that, the change. In other words, when you look at the state of the various, the regional council documents in particular. But so in other words, it's, one says yes, one's trying to bring a properly initiated plan change that the Act provides for it, but as a matter of discretion, there are certain issues that have to be decided. And the question is whether some of them centre around the stage that the regional planning process is at.
Well, Indeed, sir. And so if you look at the provisions, I would say it would be 75 or maybe 74. But certainly, it is a question of, I would say, of what weight you would give to these. So very weight one would give to a spatial plan, which is only just commenced. So certainly the Act doesn't require you to have particular regard to a spatial plan that, as I said, is very embryonic in its development. And certainly, you're not required to have, I would say, any regard to a review of the regional policy statement, which on best time
I understand your argument.
Yeah. So finally, and this is essentially going back to the sort of reconciling the higher order and lower order documents, where Mr. Langman advances two solutions which he says reconciles the NPS with the prescriptive power to ever limit objectives and policies of the regional policy statement. So the solutions involve two alternative procedural pathways, one of which is for the district council to request a change to the RPS. The other is an application for local authority to seek a declaration to the Environment Court under Section 80 in the RMA. In respect of the latter option, they have to rhetorically ask why neither the regional or city council has taken this step to date. And regardless, because it's not a step that's not a step that the plan change applicant can take. There's only a step, that application for declaration is only available to a local authority. It's not available to my clients.
Sorry, what declaration do you envisage he's talking about?
I think it'd probably be best sort of explained by Mr. Langman himself, I would say.
I'll certainly ask him that question. Thank you, carry on.
So, and regardless, there's nothing in the NTS which suggests that approval for a private plan change application should be contingent on an individual local authority undertaking a parallel or later in time process of requesting a change to the RPS. Rather, as is explicit from the discussion document and decision referred to above, and is clear from policy aid, private plan change applications must be considered on the merits. It should not need repeating that the private plan change mechanism has been a feature of the RMA since its inception, and it is a mechanism specifically recognised in policy aid of the NPS. With respect to Mr. Williamson, on behalf of a number of the submitters, I say that the witnesses for the applicants will respond in detail to what he has said, but as an observation only, the applicants' witnesses, and indeed the applicants themselves, are very familiar with the settlement planning framework and how to translate the zoning of land on paper into the reality of houses on the ground. They are fully conversant with how development is intended to happen within this framework and how it does work as intended, and indeed without any risk of significant cost and burden to the community. So that this plan change seeks to adhere to this well-established and proven framework. And in contrast, it's unclear whether Mr. Williamson has a working knowledge of how development occurs within the district, including the application of the living aid provisions in the district plan, the council's current development contribution policy, and other relevant provisions of the council's long-term plan. And it's the latter which has programmed in a range of imminent, and I say imminent as in within the next couple of years. And that's addressed in detail in Mr. Smith's evidence. So these are imminent infrastructure upgrades to support growth in the district. It is equally unclear whether Mr. Williamson has read the evidence of Mr. Colwell and Mr. Sellers on the issue of demand and supply, and if so, whether he has understood that this demand is simply not catered for in the operative district plan as is required by the NPS. Mr. Williamson refers to documents such as the Urban Development Strategy from 2006 and the Prebbleton Structure Plan, both documents which are essentially out of date and certainly not reflective, and this is obvious, of the requirements of the NPS. And again, it appears from his evidence that the NPS is not deemed to be of particular relevance to him. If so, there is no analysis of this higher order document which the district plan must give effect to. With reference to a statement that it is highly irregular to apply for an advance in application for a plan change when a proposed plan is underway, this opinion does not take into account the responsiveness provisions of the NPS, nor does it recognise the simple fact that the council has went through a process under clause 25 of the first schedule, which concluded that notification and processing of the application was appropriate instead of being highly irregular. Simply put, the applicants are entitled to have the plan changed determined now. Mr. Williamson also appears to be unaware of the extent of submissions on the proposed district plan, including further submissions by his clients. Fundamentally, however, the proposed district plan does not carry any weight at this point in time, certainly not in respect of plan change applications such as the present. Finally, Mr. Williamson agrees that the site has strategic importance in the context of future growth of Prebbleton and Greater Christchurch. So if the importance of the location is accepted, it would seem that the main concern is as to process. And in that respect, again, the private plan change process has been an inherent feature of planning under the RMA since its inception. In respect of, I've categorised the Me Too as Me Too submissions. I'd say the applicants are neutral as to whether or not the additional land on the edges of the plan change should be included. As the Commissioner will have noted, the applicant's experts have provided advice as to whether or not the Me Too land can be incorporated into the plan change area. And all are of the view that it can. And likewise, the applicant's endorsed Mr. Cleese's well thought out analysis and reasoning for including or excluding, as the case may be, additional land. There remains, of course, an important jurisdictional issue as to whether or not there's scope to include this additional land. And that comes down to the question of whether or not the submissions in question are on the plan change. And we understand Ms. Limmer will address you in more detail on that tomorrow. She's certainly welcome to do so. But we just set out a very brief summary of the relevant case law, including the leading authority of Clearwater, which incorporates a bipartite test, and that is a submission could be fairly regarded as on a variation if it is addressed to the extent to which the variation changes the pre-existing status quo. But if the effect of finding the submission on the variation to be permit amendments to a planning instrument without any real opportunity for participation by those potentially affected, that is a powerful consideration against finding that the submission was truly on the variation. It is important that all those likely to be affected or interested in the alternative method suggested in the submission have the opportunity to participate. So a submission that came out of left field, which proposed something completely novel, would be unlikely to be found on a variation. Clearwater does not exclude zoning extension by submission. Incidental or consequential extensions of zoning changes proposed on a plan change are permissible, provided the submissions do not raise any matters that should have been addressed within Section 32A evaluation report. And if no further Section 32 issues are raised as a result of the submission, there is less reason to exclude it from the plan change. Persons directly or potentially affected, should have been given the ability to respond to the additional changes, and the submission is not out of left field. So that's a summary, really. And that was confirmed in the motor machinist case, and where in respect of B2 submissions, the court reaffirmed the fact that incidental or consequent extensions are permissible. In given the expert analysis regarding inclusion of the property is unlikely that further substantial analysis under section 32 is required, including any further assessment under 32AA. But in terms of the second limb of the clear water test, the Commissioner should of course be conscious not to disenfranchise parties that may be affected by an extension of the zoning. This is a matter of judgment, knowing of course that different considerations may apply to different properties. And at the same time, we simply note that there's a high level of interest, there has been a high level of interest in the plan change. And it is certainly the case that parties with a strategic interest are already submitters, and there are a wide variety of, a wide number of residents from Prebbleton who are already submitters. And these factors should assist in diminishing any natural justice concerns you may have.
Supporting there, the Palmerston North case, I'm familiar with that. Justice Koch there talked about his concern about participatory right. And what he said was that the participatory rights of those who haven't already submitted are dependent on seeing the summary of submissions, apprehending the significance of their land, and lodging a further submission. Now, I take it as a matter I should be addressing tomorrow, should I? That's, I'm very conscious of the legal principles which go on those. I won't comment on those at the moment, obviously, but should I address those to counsel for Mr. Shammy?
I would have thought that would be an appropriate time to do so.
Certainly, if you want to say anything about that.
Just in the sense that, you know, sort of the summary of submissions on the submissions seeking a rezoning were fairly explicit, shall we say. You know, so any.
Yes, but the question is, those that weren't within it, whether, and I have no view about this, but I just identifying the legal point, and that is those that were not within it and didn't submit, then are faced with others saying, well, their land should be included, which includes, in some cases, the land of someone who hasn't made a submission. So they wouldn't know about it unless they'd actually seen the summary and taken steps. The issue is, well, would they reasonably have done so? I have no view about that.
Okay. Again, sir, we're fundamentally neutral on this issue.
Yes, I'm not expecting you to comment on it, but I'm just, anyway, the legal principles are pretty clear, and I'm grateful for you raising them with me. Thank you. Just carry on.
So we're thankfully at the conclusion, but in summary, it's evident that the current planning instruments, the regional policy statement and district plan, do not give effect to the NPS. While the latter promotes the use of development strategies to broadly identified areas for long-term development, it also incorporates a clear direction that local authorities must be responsive to plan changes such as the present, which add significant additional capacity. The use of plan changes generally represent a more flexible tool for responding to demand when it arises, as opposed to long after. Once the responsiveness requirement is accepted by the Council and the application given consideration of its merits and what it can deliver to Prebbleton and beyond, we submit there's no reason to decline this proposal. There's a dire need in our submission to provide additional capacity now, and if now is not the right time to utilise the responsiveness pathway, then when? I should say these were submissions prepared with assistance from my colleague Ms. Parsons, who has been struck with COVID and can't appear.
Thank you. Just there's one fundamental matter. Can I call the enabling housing supply, I call it the Enabling Act, so we know what we're talking about. The Enabling Act was passed, and the Selwyn District Council prepared a report which was presented at the meeting on the 23rd of February. And it is proposing to notify a variation by July 2022, I think, is that right?
I think the requirement is no later than August, so that sounds about right.
And then, of course, the amendment, the Enabling Act provides that a variation must be notified by the 20th of August. Now, there was a document which you'll be aware of, and that is which I call the variation. Let's call it the variation document, which is the report to the council, the variation report, we'll call So that was submitted to the council on the 23rd of February, and it set out a whole lot of, well, what are we going to do about this? How is it going to affect privately initiated plan changes? And just let me just. Sure, I'm just trying to find the document, just give me a second. So it looked at the options, and then the council then, as I understand it, agreed to proceed on the basis that there'd be a variation prepared, which included Prebbleton, and it would include private initiated plan changes that had a decision recommending approval in Prebbleton. So I'm confused about this. This is a privately initiated plan change to an operative plan. And if I approve it, it appears that it will not be approved by the council. The council has specifically resolved, unless I got this wrong, not to approve it pending the promulgation of the variation and people having the opportunity to submit to the variation. Now, this seems an unusual situation because everyone's having an opportunity to just make submissions in relation to private change now. Mm-hmm. If I approve it, my understanding is that the council will ensure that, well, actually it'll have to be a submitter, I think, making an application or a submission, which will result in those provisions going into the variation and then it'll be part of the variation. And then, as I said before, the submitters would have another opportunity to make submissions in relation to the variation because it wouldn't have been made operative and it becomes part of the variation. I'm confused as to that process. It seems that there's two bites at the cherry, which seems unusual. In other words, if I approve this, it's not the end of the road. It won't result in the plan becoming operative because of this resolution of the council. And it says the process will allow for the public to submit on the proposed variation and for further submissions to be received post that. So where does that leave this process? It seems to me that I'm in a situation where I will make a decision one way or the other in relation to whether the plan is approved or not. I'll either approve it or not, the change. That's what I've got to do because that's the statutory position that I'm in, and I make the recommendation.
Well, there's of course a halfway house.
Well, it's a halfway, and then the next thing is that if I do approve it, the question then is whether there'll be any appeal rights as well, because it wouldn't be made operative. It's just a recommendation by me, and it won't become operative until such time, if I'm reading this correctly, until such time as the variation itself becomes operative.
That would be that would be a reasonable summary. I would have thought, and I would certainly agree that the Enabling Act we should probably refer to as the Complexity Act, because it has created a sort of a raft of headaches for the district council and indeed private plan change applicants. The Act is very clear now in the sense that private plan changes are to be allowed to go to a certain point in the process. And the point in the process that it goes to is that you make a recommendation. The council makes a decision whether or not to accept your recommendation.
No, but it's not going to do that until after the variation.
Well, so, yeah. So
that's the point. The point I'm making is that if I'm right, if I'm reading, and I think we need to get this clarified, I'm not, you may want to check this out because it's really important, because it seems to me that I can make a recommendation one way or the other and give reasons for it. Let's say if I were to approve it or to recommend its approval, and it then becomes part of the variation, there is then the prospect that the next commissioner that hears the submissions on the variations will say, well, that's a lot of rubbish. I don't agree with that. I'm going to form a different view about it.
I think
And that troubles me.
that seems to be a prospect for all of the plan change applications. I think my understanding,
I mean, maybe that's just the way it is, but it's not.
Sort of my understanding is that that if I had a look at this, my understanding is that the council will, Mr. Please may be able to assist here, but the council will actually issue a decision on your recommendation.
Well, in relation to the one that you referred, in relation you referred to the previous one, which is the one which that was changed. It was Mr. Corbell's one, which I can't remember the main number of the change, but anyway, that one, I understand that the council did approve that. There seems to be, doesn't seem to be consistent with the resolution, which was that they weren't going to approve the recommendations until such time as they become part of the variation and gone through that process. So I'm confused.
Of course, the difference is the fact that West Melbourne is not an area identified for intensification, so it would not be caught by the variation.
Ah, yeah. I think you've answered the question. I think that the recommendation here relates to Rolleston, Lincoln, and Prebbleton.
Yes,
that would be the answer I take it would be. This will need to be confirmed, but the fact that it's West Melbourne, which is not Lincoln, Rolleston, or Prebbleton, may mean that this resolution doesn't apply to it.
It doesn't apply, so that's my understanding. Yeah. Indeed, as I said, it's a complex situation that we're all faced with. If, for example, so the plan change applications within the future development areas identified in the OPS, but my understanding is that as with an application such as this, the council will take all steps under the first schedule, other than the final, I would say, sort of essentially administrative steps.
Well, I think it says here, it's got it clear, I've looked at that, and it's not, it's clause 17 is the one where I think there's approval, they're not doing that.
No.
So there'll be no approval. So all that's happening is, I think, is that they're receiving
Your
my recommendation.
Making a
Here we are,
decision.
meaning that they should progress. This is from the document, I'm reading from it. While there is no provision that says these applications should be placed on hold, meaning that they should progress entirely through the typical Schedule 1 process, legal advice confirms that they should not be approved under Clause 17, Schedule 1, or made operative under Clause 20. To do so would mean the application would no longer be varied, could no longer be varied, which would mean the purpose of the Act, which is the Enabling Act, would not be achieved.
So indeed, but Clause 17, of course, follows after the issue of the decision and appeal rights.
So what was that?
It follows, so the issue of the decision under Clause, I'm going to say Clause 10, and then there's the right of appeal under Clause 14. So obviously, Clause 17 refers to later.
Well, just let me look at that. So is my decision a decision under Clause 10?
So it's a recommendation.
That's what I thought.
Yeah.
And you see, that therefore Clause 10 won't apply, will it? Because
if the council, as I understand, will, the council will issue a decision on Clause 10, either accepting or rejecting your recommendation.
without I see, without actually approving it under Clause 17. So you're saying there's a difference between, so I'll make a note of that, this is quite important.
And Mr. Cleese will also
Yeah, I'm happy to chip in here if that would be assistance, but I don't want to speak out of turn either. But look, as Mr. Cleary sort of said, there's my understanding of how it works is that you make a recommendation to council.
Yeah.
Council adopts your recommendation. The appeal period begins. If there are no appeals, then normally it goes back to council for a second administrative process to make the plan change operative. So it's that second and last step that the council won't make. So the plan change sort of remains inoperative and therefore able to be sort of.
So you're saying under clause 10, the appeal period, so I'll start again, under clause 10, the council will either accept or reject my recommendation.
Yes, appeal period begins.
But it won't take a step under clause 17, which is the actual.
That's right.
Yeah, right, okay.
And the reason for this is because the.
I know the reason.
Yeah.
It's in the variation.
Yes.
Well, I presume it's the same one. The variation.
Yes.
The variation report.
Yes.
Yeah, it's the same reason. I know.
Yes, and this, to a certain extent, this two-step process has always been here because we have a proposed plan that's out at the moment. Submitters or applicants rather have always realised that they go through a private plan change now. Before the Amendment Act came out, they've also invariably all submitted on a proposed plan. So, yeah, before the Amendment Act, decisions would have issued on the operative plan change. It would have become operative. But then the proposed plan is still out there, so there's always going to be that second bite of the cherry where they accepted, or applicants have always accepted that they have to be submitting on the proposed plan. Other decision makers on the proposed plan will still make a view about whether to confirm the new urban boundaries or not. And so the variation of the proposed plan essentially just continues on that two-step process. Except now,
But we're talking about the second bite in relation to the proposed plan. How does, if this is approved, if I were to approve this change and it were to be accepted, that recommendation accepted by the council, how does that get into the proposed plan?
the council, in doing the variation to the proposed plan, so the proposed plan at the moment has urban boundaries that reflect the status quo. The variation to the proposed plan would also include the new geographic, this site as an additional geographic area.
Oh, in other words, the variation we're talking about in here,
Yes.
that variation they're talking about promulgating.
Yes, to the proposed plan. So if you like, your decision, council are cognizant of them. If you recommend approval, then obviously you're satisfied on merit that it contributes to good urban form and there aren't any other reasons to say no. So council then take that geographic confirmation that this is a logical extension of the township and include that in their variation to the proposed plan that effectively sort of setting the new urban boundaries for the proposed plan going forward. With a layer of sort of medium density and neighbourhood.
So just to make it clear, I see. So the variation, do you mind if I?
Not at all, sir.
The variation which we're talking about here has two functions. One, to ensure that there are provisions reflecting the Enabling Act so that you can build 3 stories and all sorts of things. That's the main reason why there's a variation. But at the same time, the variation would include any plan changes where the recommendation has been accepted by the council but not approved under clause 17. Yeah, okay, thank you.
So essentially, there are 2 parallel variations that are going to be amalgamated. The first one is the council's variation for the existing urban area, and the parallel variation is for additional land, where the recommendation is to approve a rezoning of that land.
But,
and so this land fits in that
but the
section.
point is, from the point of view of the landowners, the submitters and whoever else, if it were to be approved, they couldn't take advantage of that until such time as the variation had gone right through its various stages and become operative.
That's correct.
That's good.
That was one of the side effects, I guess, of the Enabling Act. It wasn't meant to enable additional housing. Effectively, it's delayed the potential implementation of housing by another year or so, because the operative plan changes never become operative, so you have to
So
wait
it
for
wasn't the
duration.
enabling act, you were just left with the national policy statement.
Hmm.
Then you would have, in the event of the change being approved, you would have expected to have a lot more quickly than, and the enabling act is actually slow.
Delay things down.
So I just want to make a note of that. Right, well, thank you, Stu, for that. As we discussed before, I just had a discussion with Mr. Cleary, asking him to make available to me the notes, the documents which are in his footnotes, unless he knows that I've got them. For example, he knows I've got the national policy statement and the document for that. So we're now at the stage where we call Mr. Colgrave.
And Colgrave, who's appearing via Zoom link, and there he is.
Is there a summary?
Mr. Colgrave has prepared the summary,
I haven't got
and
it.
you haven't got it. That's a little issue.
I seem to be accumulating a few documents here, so. Oh, okay, thank you. I think I've got it. No, I'll do it put on the file.
So I did file all the summaries with the council yesterday, and they haven't appeared on the website yet.
Well, it came through actually, and I think it was sent to me by email, but I said that I was here.
So all of the other submitters will be here in person, all of the other witnesses will be here in person, so we'll have copies of their summaries.
All right,
Okay, Mr. Colgrave.
just give me a second.
Jerry, you have the copies of everybody's?
You got. Should we, is there a photocopy here or not? Have you've got,
They're available on the website and I've sent them all to the submitters by email, so if you have a device, you could get them.
I have a copy here, I've only got one copy. I take it you've got the copy of the main evidence, it's just, this is a summary.
Oh, this is just my evidence I'm talking about.
Oh, okay. Well, perhaps they can be made, copies can be made available as soon as, of the summary.
Sorry?
I can always make a whole bunch of copies of everybody's.
We're waiting for the submittal.
No, sir. What I've actually arranged for is for Mr. Hall will get copies of all the summaries. I had anticipated that the witnesses would bring copies of the
Yes.
summaries. But
So has someone gone away to photocopy them or what?
yes, Mr. Hall has done that.
Well, can we wait? I don't think we should be able to get through all this today.
It may be quite, I'm not expecting them to be back for a little while, so. But you have a copy of Mr.
I mean, I'm all right, but I'm just concerned about the submitters not being here and not hearing the evidence.
This is obviously a recorded hearing. So the submitter,
How long would it be before the submitters return with the copies?
I think maybe sort of half an hour.
But it's not a submitter, it's a witness.
Yeah,
It's gone.
but sort of you don't get copies for the benefits of the people who are here today and for the people who are watching online. But he will be reading out, all the witnesses will be reading out. So there's no, the summary, so there's no disadvantage. In fact, apart from the fact that they don't actually have a hard copy of the witnesses' respective summaries in front
The
of them.
submitter's gone away to do the photocopying and that submitter won't hear the evidence.
Excellent.
I'm sorry, I think we should wait.
So
I think it's important that they hear this evidence. Mr. Colgrave, is that going to be a problem for you? We've got a problem about copies of evidence and someone's gone away to get them photocopied. Is it a problem if you were to wait a period, it might be 20 minutes or half an hour before this, is that going to be a problem for you or not?
No, that's fine, sir.
It wasn't a submitter, it was one of Mr. Cleary's experts. He's gone away to do a photocopy.
Oh, I'm sorry, that's your,
Yeah.
my apology, I didn't introduce them.
Yeah.
I see, okay, you're expert, right. So all the submitters are here.
yeah, and any submitters who are interested in the process would be watching online, so they can actually hear the individual experts present the summaries.
So in other words, the point is that all the submitters will be able to hear the evidence now, and they'll get a copy when your expert returns. Has anyone got a problem about that or not? Right, all right, we'll commence. That's fine. Thank you. Thanks, Mr. Bell. I'm sorry, I was across purposes over there. Was there. Mr. Colgrave, just go ahead with your summary, please.
Thank you, sir. I've ditched the jacket too, sir. It's very hot in this room, so.
Sorry, we're going to have to have. We've got to be able to hear you. The submitters can't hear what you're saying. I can just hear you, but the submitters can't hear you.
Plan change 68 seeks to rezone approximately 67.5 hectares of land in Prebbleton to accommodate around 820 dwellings and a small amount of supporting commercial activity.
Just a minute.
Yeah. Try that again.
Just try that. Just speak now. Just see. We've just rearranged the.
Plan change 68 seeks to rezone approximately 67.5 hectares of land. Is that better, sir?
Yes. Thank you. Can you hear that? Yes, thank you. Everyone can hear. We're all on the same page. Thank you.
Great. Okay. To accommodate around 820 dwellings and a small amount of supporting commercial activity. My evidence profiles Prebbleton's existing residents and dwellings and shows that the Selwyn District's population has grown rapidly in recent years, with this fast growth projected to continue well into the foreseeable future. Having carefully reviewed the latest 2021 housing capacity assessment prepared for the Greater Christchurch Partnership, I consider that the Council is not currently meeting its NPSUD obligations to provide at least sufficient capacity to meet the demand for new dwellings at either the district or sub-district level. This is both because the Council's estimates of demand for additional dwellings are too low, whilst estimates of likely capacity to meet that demand are overstated. When the various issues identified herein are addressed to provide more realistic, reliable estimates of dwelling supply demand, I consider that the district clearly faces significant supply shortfalls under the short, medium, and longer terms. Accordingly, additional land needs to be identified and rezoned as soon as possible to meet NPSUD obligations and to enable the efficient operation of the local land market. Overall, it is my assessment that the PC68 proposal will provide strong economic benefits, including One, providing a substantial direct boost in market supply to meet current and projected future shortfalls. Two, bolstering land market competition, which helps deliver new sections to the market quicker and at better average prices. Three, providing a variety of housing options and typologies to meet diverse needs and preferences, which is also required by the NPSUD. Four, contributing to achieving critical mass to support greater local retail and service provision. And fifth, the one-off economic stimulus associated with developing the land and constructing the dwellings that will be enabled there. Given the strong and enduring benefits of the proposed plan change, and noting the absence of any material economic costs, I support it on economic grounds. Mr. Langman has filed evidence on behalf of Environment Canterbury and Christchurch City Council, which levels various criticisms at my evidence. For example, at para 65, Mr. Langman argues that my evidence focuses too narrowly on population growth in Selwyn, and that it should instead focus more broadly on Greater Christchurch. I disagree. The purpose of my evidence was to determine the need for, and hence merits of, providing additional residential land to meet the need for new dwellings in Prebbleton, which is a sub-market of the Selwyn district housing market. While I acknowledge that there may be some overlap between the district's housing markets and sub-markets and those elsewhere in Greater Christchurch, I categorically reject Mr. Langman's insinuation that they are perfectly interchangeable, and hence that people would realistically trade off a potential new dwelling in Prebbleton with one located in, say, Fendleton, Sumner, or Marshlands. Such statements represent a fundamental misunderstanding of how housing markets work, and they also defy the real estate evidence of Mr. Jones and Mr. Sellers for other plan changes, which clearly identify the district as catering for a specific segment of the sub-region's overall housing market. I also note that Selwyn's population growth is exceptionally high, the highest in New Zealand by far, but that the city's growth has stagnated. Specifically, while Selwyn's population grew 4.8% during the 12 months ended 30 June 2021, the city's population grew by only 200 people, or 0.1%. Further, while Selwyn's current population currently far exceeds Statistics New Zealand's high population projection, the city's population is languishing between its respective low and medium scenarios. Accordingly, housing demand is far more acute in Selwyn than in the city or the rest of the sub-region. Mr. Langman, however, does not appear to acknowledge these basic facts. In my opinion, it is not, as Mr. Langman states, a perception of high demand in the Selwyn district. Rather, it is a very real and should be undisputed. From paragraph 100 onward of Mr. Langman's evidence, he provides his views on housing demand and the need to provide corresponding increases in housing capacity. He opines at paragraph 103 that demand should not be used as the driver of increased supply, and that doing so would necessitate an increase in supply across the sub-region's more expensive suburbs. I am perplexed by this statement. Market supply is, by definition, tasked with meeting increasing demand. So the notion that demand should not be used as a driver of increased supply makes no sense. Taking a step back, it appears that Mr. Langman interprets widespread increases in house prices as evidence of a demand for additional dwellings. While house prices are certainly part of the puzzle, I consider builder consent trends to be a better measure of underlying demand. And I note that the district's recent consent volumes far exceed all projections. The same is not true for the city, though, where growth has slowed down markedly. Paragraph 107 of Mr. Langman's evidence adopts a range of comments previously made by Mr. Talentire on earlier plan changes in which I was involved, and which I have already debunked. For example, at para 107A, Mr. Langman considers the 2021 capacity assessment that I critiqued is generally consistent with requirements for preparing them, including the use of population projections as the initial basis for an assessment of housing demand. I disagree. The demand projections used in the assessment significantly understate recent trends, and its corresponding estimates of capacity are fundamentally flawed, as described in detail in both my evidence in chief and that of Mr. Akehurst for Plan Change 69. At para 107B, Mr. Langman also considers that the prior housing capacity assessment was generally fit for purpose because it included a peer review process. In my view, that earlier housing capacity assessment was fatally flawed because it assumed that all plan-enabled capacity was automatically feasible for development. This is an inappropriate and misleading assumption. Moreover, the supposed adequacy of the prior capacity assessment tells us nothing about the accuracy or otherwise of the most recent 2021 iteration. At para 107D, Mr. Langman refers to a list of private plan changes within the future development areas and also the code fast track consent for Farringdon, and concludes that this will meet the medium-term capacity figures in Table 3 of the HCA. Mr. Langman goes on to conclude that at least sufficient development capacity to meet demand has already been identified, and indeed that there is a medium-term surplus capacity of between 3,667 and 4,961 households. However, as it identified in Section 9 of my evidence, such conclusions are incorrect, with the district facing significant shortfalls of capacity. At para 107E, Mr. Langman claims that the various factors identified in my evidence as potentially limiting market supply relative to feasible capacity will not be significant over the medium term, and hence that they can be discounted accordingly. Notwithstanding the abject lack of evidence supplied by Mr. Langman to support this seemingly sweeping generalisation, the factors that I have identified have materially reduced market supply in urban areas where I have performed similar analyses. For example, in 2006, the various territorial authorities that now comprise Auckland Council identified a significant amount of capacity available via the intensification of the existing urban areas. However, a 2018 report by Auckland Council showed that only 11% of that capacity had been taken up 12 years later, largely because of the factors that I identified as limited supply. Further, I failed to see how a spatial planning process could, as Mr. Langman states, address material reasons why feasible capacity may not be converted into market supply. No supporting rationale has been provided in support of this statement. Para 107F of Mr. Langman's evidence argues that the triennial capacity assessment process is the most appropriate way to identify and plan for additional capacity to meet shortfalls. I agree that that process can be a useful avenue to provide for future capacity, but it's not the only way, nor necessarily the best. The issue is timing. In short, with a 3-year gap between each capacity assessment, and given the very long lead times associated with both land development and house construction, relying just on capacity assessments to address capacity shortfalls is flawed, in my view. A far more responsive approach is desirable, both from a market and a regulatory perspective. Finally, Para 107G of Mr. Langman's evidence states that I have not considered the impacts of the new medium density residential standards, which were ushered in via the recent Amendment Act. I agree that my evidence does not explicitly consider them because it focused on addressing the issues that I identified with the latest capacity assessment itself, which predated those reforms and hence also excluded them. Given the uncertainties in how the MDRS will be implemented, I consider it premature and speculatory to undertake this exercise. However, I confirm that I do not consider the MDRS to have any material bearing on the district's likely supply-demand balance. District land prices, the age of the housing stock, and local housing preferences simply do not lend themselves to the sort of density uplifts enabled by those provisions. So caution should be applied in assuming any immediate drastic rise in housing capacity released through the new legislation. That caution is even more relevant if one were to take into account the fact that many of the inhibiting factors towards converting feasible capacity into supply, as per para 9.23 of my evidence, are likely to apply just as much to intensification as they are to greenfield development.
Thank you, Mr. Conrad. You mentioned take that mask off, the Enabling Act. Well, there's been mention of the Enabling Act, and your position is that there's considerable uncertainty as to what that will result in. Anyway.
Well, I don't believe it's uncertainty, sir. I believe that I have a reasonable degree of certainty that I don't think it will have an effect. And that's because there's a few factors here. The first one is that a policy like that will have a very big impact in areas with very high land prices. So, the Auckland and some of those very metropolitan areas with very high land prices. In those areas, the ability to have additional density can mean the difference between a development being feasible and not feasible. But in more provincial areas, for want of a better term, where land prices are still relatively modest, it doesn't tend to have such a great effect. But and there's a couple of other factors that are important here. The second one is that a lot of the housing stock in Selwyn is very new. A lot of it was built since the year 2000. And so you're looking at reasonably new dwellings on new sections, if you will. And the case for redeveloping or intensifying is really taken away when you're looking at a new dwelling on a new section, that kind of thing. Redevelopment only becomes feasible when you're looking at quite an old run-down dwelling, which is not making a good use of the land. So, for example, again, in parts of Auckland and Wellington and Hamilton, some of the older housing stock that might be 50, 60, 70 years old, it's coming to the end of its useful life. It's on a reasonably big section. Those are the places where medium density redevelopment actually makes sense in terms of being commercially feasible. So you've got low land prices, you've got a relatively new dwelling stock. And the third factor that really matters here is the sort of housing preferences of people that want to live or are currently living in the Selwyn district. A lot of the housing stock is single story detached dwellings, and that's the sort of preference that people have. So I'm not saying that medium density development won't ever occur in Selwyn, but it's not going to suddenly occur en masse just because of these provisions. So it's one thing to say that it's enabled by the Act, but it's also important to then consider the economic and market factors and whether that capacity or that opportunity is likely to be taken up. And in my view, and Mr. Salles has expressed the same view previously as well, it's just not going to have an effect, certainly not over the next sort of 5, 10, 20 years in Selwyn.
So is the main reason then looking at Selwyn, I'm sorry, I am finding it a little bit difficult to hear you even now. I wonder if the microphone will be put a wee bit closer. Can you hear you okay?
Not too bad.
It's not easy to hear. Thank you. Thanks very much. Looking at the Selwyn situation, is the main reason why this type of development will not take place because it will be too expensive to remove quite expensive existing housing, etc., to enable the. That's the real issue, isn't it?
That's correct. That's correct, sir. And I'll speak loudly, so hopefully you can hear me better. Redevelopment is a very expensive exercise, particularly if you've already got an existing dwelling on a site and you have to demolish it and remediate the land and start again. That's very expensive, and so you would only typically do that with a very old dwelling that's near the end of its useful life, and you knock it down and you build something new in its place. So redevelopment really only makes financial or economic sense in areas that have a very mature housing stock, land prices are very high, and you have a community that's used to medium density development and wants to live in it. Those factors just aren't at play in Selwyn district right now. They may be in 30 or 50 years' time when things are different, but right now, these provisions could come in, but there's just no market appetite or market factors that would lead to this being taken up in any sort of degree that would make an effect. So
there's no housing stock that would immediately, because of its, there's not old housing stock. There's predominantly not old housing stock. It's predominantly new housing stock, and therefore that deals with the existing development. What about the developments which are coming on stream?
Sure. Yeah, so there may be some developments at the margin which decide to bring in some higher density than they might have done otherwise. But it's important to recognise that high density development is actually quite expensive. You need stronger foundations, and building something above the ground floor is a lot more expensive than building on the ground floor. So building that second and third story is much more expensive. So you might be using less land, so that's cheaper, but you need much stronger foundations. The cost of building the second and third floors are much higher. But more importantly, I've not seen any evidence of people who want to move to Selwyn to live in a medium density situation. my understanding and my experience, having worked across Greater Christchurch since around 2005, is that if you want to live in a medium density situation, you're more likely to gravitate to the city. And if you're looking for more of a, not necessarily lifestyle, but a more, a bit more land, a nice sized dwelling, single story, that's the kind of demand that you're getting in Waimakariri and Selwyn. So there may be the odd developer who decides, yes, I'm going to build a duplex, I'm going to build a townhouse, and that could certainly happen, but we're not going to get all of a sudden a whole lot of people building medium density in Selwyn, because the market demand is just not there for that sort of product in this location.
You're directing your comments to Selwyn, aren't you? Because you're saying that the sort of person who would go and be a purchaser in Selwyn is unlikely to be someone who might have put a 3-story house on the block. They're looking for something else.
That's right, sir. I mean, I've done a lot of work in Waimakariri as well very recently. So I've worked a lot on these 2 districts which flank the city. And it's a very similar situation. For example, in Hamilton City, you've got Waipara and Waikato. In Auckland, you've got Waikato and Kaipara. It's a very similar situation where you've got an urban area which is flanked by districts, and the sort of housing that tends to occur in those districts is lower density housing, and people have gone there because that's what they're looking for. So again, there may be some medium density housing occurring over time, but certainly there won't be a wave of additional capacity released by this legislation in the district.
That leads me to the question which is being put by some of the submitters, which is, well, shouldn't we really wait to see what transpires from the variation, because the council's got to have a variation by the 20th of August of this year to implement the facility, the ability of councils to be able to introduce these things. And some will say, well, why don't we wait? Because this may, they would say it may be relevant to the issue of meeting the demand which Mr. Sellers has, and you indeed have both emphasised it exists in Selwyn.
Look, I mean, my very strong view is that it's not going to make a difference. And more importantly, the evidence in front of you, sir, is that over the longer term, there is a really pressing, a very large shortfall in capacity, somewhere up to 18 to 20,000 dwellings. And even if you were to accept all of the plan changes that have been put forward, you would still have 9,000 to 10,000 housing shortfall over that longer term. So, something miraculous will have to happen, and it's not going to happen through the MDRS provisions, in my view. And so when you think about the timeline for land development and housing and infrastructure and all that kind of thing, it's several years from the day a plan change is minted to the day that the first house is open and people move in. It's a very long process. And so given those long lead times, and given the extremely high demand the district's facing and the shortfalls that are already on the horizon, in my view, delaying would not be an appropriate strategy. I think we need to move with pace. I'm not saying we should move at such a pace that we make bad planning decisions, but these processes are availed of expert evidence across all the relevant disciplines, and there's a lot of thought going into these plan change processes. So I think the idea of waiting and seeing would be very unwise given the context.
Just on that point of waiting, there's a slight complication as I see it, and that is that if I were to make a recommendation that this plan change should be approved by the council, then that will form part of the variation, which will also have the enabling legislation in it, so to speak, and then that'll have to be confirmed by the council, or considered by the council, should I say, submissions required, and then should it be approved, and it'll become operative in due course. So the question I have is, in fact, given that scenario, is it actually going to, delaying with a view to seeing what happens with the Enabling Act actually going to delay things given that rather unusual scenario?
Yeah, look, I profess, I did listen to the discussion you had with the people in the room. I can't I can't say that I'm quite across the detail of all those intricacies, but yeah, I mean, possibly there is some roadblocks along the way, but I think it's really important that to the extent we can, we just start getting on with it really, acknowledging that things might not go as smoothly as we'd like down the track.
So you think it's important to get on with this process and either approve or not approve, just to keep the thing moving? Is that what you're saying?
Yes, that's my view, sir.
Your second, Mr. Coote. Thank you, Mr. Coleman. Sorry, I called you Mr. Costro, Mr. Coleman, sorry.
Right.
Thank you very much.
We're just slightly going to go out of order. We have Mr. McDowell.
Thank you.
Okay, thank you, sir.
You're free to leave.
Thank you.
Sorry. So I think, sir, that now we have the problem here. So Mr. McDowell has copied the summary for you.
Thank you. Good morning.
Morning, sir.
Would you like to read your summary? Thank you. Speaking to the speaker.
My name is Victor Mtamo. I prepared evidence on the versatility of the soils within the Plant Change 68 area. And now I read the summary of my evidence. Starting from paragraph 3. The PC 68 area includes 6.13 acres.
Can you hear over there?
The speaker has a wee bit.
I'll bring it right next to your face, so please.
Thank you. Is that better?
Thank you.
The PC 68 area includes 36.13 hectares of land use capability LUC Class 2 soils and 7.57 hectares of LUC Class 3 soils. The remainder contains Class 4 soils, which are not considered as being versatile. A review of the site-specific factors relevant to the productivity of those soils indicates that the climate in the area causes soil moisture deficits. Water is not available for irrigation to mitigate the effects of the deficits and meet the crop demand. This severely constrains intensive crop production. The volume of water required for irrigation is 472,028 cubic meters. I have estimated that almost $1 million is required just to buy and transfer consents to the Plant Change 68 area to irrigate for full productivity. Nutrient application rates will be limited by the nutrient limits set out in the Canterbury Land and Water Regional Plan. Reducing nutrient applications affects the crop yield potential. Therefore, the soil productivity potential is not realized. Advances in technology and farming techniques over the years have been such that the removal of up to 43.7 hectares of these soils is unlikely to result in any significant loss in the production, as this can be made up for elsewhere in the district and even on soils of lower LUC classes. The developable area in the context of the total LUC2 and LUC3 soils in the district and in the region is very small, 0.031% and 0.0052% respectively. The PC68 area will not result in any significant cumulative loss in versatile soils, but at a district and regional, both at a district and regional level. The change in LUC classes 1 to 3 as a result of all plant changes operative and proposed between January 2018 and November 2020, when PC 68 was launched, is less than 0.36% and less than 0.06% within the district and the region respectively. The site is bound by existing subdivisions and lifestyle blocks. I expect significant resultant and reverse sensitivity issues associated with intensifying agricultural production in such an area. The officer's Section 42A report supports the inclusion of additional blocks within the plan change. This will result in the reduction in LUC Class 2 soils from 36.13 hectares without those blocks to 48.82 hectares. The cumulative reduction in LUC 1 to 3 class soils will increase from 0.356% to 0.365% within the district, 0.06% to 0.061% within the region. For these reasons, it is my opinion that the effect of PC 68 on district and regional agricultural productivity potential is insignificant. Now I address comments on the evidence of Mr. Marcus Landman. Mr. Landman states that in paragraph 153 that I downplay the importance of the soil resource. I do recognize the value of the productive soils as I have discussed in detail in my evidence. The NPS HPL recommends site-specific assessment to be taken into consideration where this is possible to remove the soil reliance on the default LU classes 1 to 3. Various other references, for example, paragraph 29, Canterbury Regional Council versus Selwyn District Council, Environment Court Judge Treadwell, in my evidence suggests the importance of site-specific soil assessments. I note that Mr. Langman does not acknowledge this requirement for site-specific soil assessments in his evidence, or when he concludes that I've downplayed the importance of productive soils. I also note that Mr. Langman does not specifically dispute any of the site-specific issues that I've assessed and their effects on the productivity potential of the land. However, for the range of reasons summarized above and discussed in more detail in my evidence, I do not consider the soils on the site to be capable of sustaining full productive agricultural uses. That's the summary of my evidence.
Thank you, Mr. Tharmo. You concentrated on looking forward as to what the effect of removing that area of soil would be, and that's your evidence concentrating on that. Have you any knowledge of the history of the use of that block? Speaking generally over the past few years, do you know what it's been used for?
Not in detail, but speculating it's low productivity uses, because I live in the area, so I drive by quite often. Characterized by typical lifestyle block uses, some bit of sheep, some bit of sheep grazing.
But there is a large area which is not really a lifestyle block area in the middle of it, isn't there?
Yeah, that's correct. Yeah.
And what's the present state of that land at the moment?
It's grassed, so grass for grazing.
So would the issue of whether the land had been used for more intensive purposes historically be relevant to your consideration of the matter if you'd had that information or not?
No. Going back to say between 2009 and 2014 and coming forward to today, the land use has pretty much been the same. But I do stand corrected if that's not correct, which is just pasture grazing, unintensified land use. Based on that, with the new changes to the Canterbury Regional Plan, there is need to establish a baseline of land use based on the usage between 2009 and 2013, though that 4-year period. that baseline defines what the land can be used for in the future with regards to nutrient applications. So the land use, in my opinion, has pretty much been the same. So based on that establish what it can be used for going forwards. Essentially, you can't apply any more nutrients on an annual basis to the land than what's been applied based on that baseline.
And you say that makes the historical analysis of, for example, if it had been used for more intensive purposes, say 20 years ago, and you'd known about that, you say that wouldn't have made any difference to your view because of this nutrient.
Exactly. So assuming it was 100% intensified 10 years ago, before the 2009-2018 baseline.
2009 to 13, was it?
2018 baseline, that's correct. So before that baseline, whatever use it was used for, if that use wasn't in place during that 4-year period, then it's no longer relevant. But adding to that, there is no water available to the land. So getting water to intensify also becomes another.
I'm just trying to see where in your evidence in chief you refer to that 2009 to 13. It's your main evidence. Have you got any comment as to where that is?
I talked about the pages are out of order, but I talked about the kind of the legislative changes, the statutory compliances.
I'll just try and get my file in order here. Use.
So if you go to paragraph 60, where I talk about the statutory plan.
16?
60.
No.
Just a minute.
Oh, that's I'm sorry. Okay. Statutory. Paragraph 9.22. So paragraph 9.23 refers specifically to that 4-year period.
Oh, yes, right. Thank you. Just let me read that with you. I just want a minute. So the point there is that it's fixed by the historical 2009 to 2013, how much nitrogen was being put on land, you can't increase it now. That's the bottom line.
That's
Therefore,
correct.
it doesn't blend itself.
That's correct. And because it was low intensive use.
Yeah, I understand what you're saying. Well, thank you very much for that.
You're welcome.
If I may, you're free to read
Thank you so much.
Thank you. Thank you. Wait for Mr. Keary to come back. Good afternoon, Mr. Hall.
Mr. Commissioner. My name is Andy Hall. I am the Engineering Director of Davey Lovell Smith. I'm a chartered engineer. I have 30 years experience in this field, including 20 years experience in Selwyn. I've prepared my evidence having consulted with Mr. Murray England, representing the District Council. Murray is the Services Asset Manager. The purpose of this evidence is to provide an outline of how water supply, stormwater and wastewater will be managed as part of the applicant's land becoming a residential zone. Consultation has been carried out with Council Officer Mr. Murray England, and this evidence is in compliance with his advice. Mr. England and myself are in agreement as to how the proposal can be successfully serviced. The PC 68 site is directly adjacent to the urban edge of Prebbleton. In regards to stormwater, the site is underlain with deep gravel suitable for direct soakage of stormwater to ground. Groundwater levels on the site fluctuate and are approximately 5 to 10 metres below ground level. This site is able to meet regional council discharge standards. This type of disposal is not always available in Prebbleton, as the depth of groundwater reduces on land closer to the Hawesville River. There will therefore be no need for us to construct stormwater basins within the PC 68 area. Stormwater will not inhibit the potential of this land to be developed. In regards to wastewater, a new pump station will need to be constructed on the lower eastern end of the plan change area. The pump station will receive wastewater from the catchment that includes plan change 68. The wastewater will be pumped to the Prebbleton wastewater pumping station and then on to the Pines wastewater treatment plant in Rolleston. The Prebbleton pump station has a limited capacity that can be improved with some minor upgrades and changes to the existing rising sewer. The proposed pump station can be provided with additional emergency storage to buffer peak flows or add additional catchment areas adjacent to the plan change area. The plan change site does not have a high groundwater level, and as such, there will be minimal ingress of water into the sewer system. Following information of some changes to the existing system, wastewater capacity should not inhibit the potential of this land to be developed. Water supply. Selwyn District Council has a strategy for the supply of potable water to the area of this plan change proposal. Should Selwyn District Council require a new well within the PC 68 area, then they can be accommodated by providing them with land. Any well within the plan change area will be transferred to the council upon development of the site, and water supply will not inhibit the potential for this land to be developed. We've received 3 submissions which relate to infrastructure. The first submission is from Zhao Chen. Mr. Chen is eager to be included inside the plan change 68 area if it is accepted, but has the following concerns in regards to infrastructure. Mr. Chen believes that if his land is not included in the plan change 68, then the integrated planning of infrastructure becomes difficult. He has concerns in regards to secondary stormwater flows of Mr. Chen's land that need to be accommodated. And Mr. Chen is concerned about the drinking water quality as a result of discharge of stormwater to the ground. In the case of Mr. Chen's land, the only reason that it may not be included would be wastewater capacity. Its capacity is the limiting factor to the expansion of Prebbleton. If that capacity is available, I see no reason why Mr. Chen's land cannot be included. All secondary flows off Mr. Chen's land will be accommodated as part of the subdivision process. This is usually addressed at the time of subdivision with a consent condition such as the following. These are examples of a recent consent in Prebbleton. The proposed development shall not discharge runoff onto adjacent properties unless via a controlled outlet approved as part of the engineering design approval. And B, in the event that an adjacent neighbour's historical stormwater drainage was onto the site, the proposed development must maintain or mitigate the historical discharge. So these issues are dealt with at the subdivision consent stage. And finally, for Mr. Chen, the quality of stormwater being discharged to ground is controlled by the Regional Council stormwater discharge consent process. If required, the stormwater will be treated to ensure that there is no inappropriate effects on down gradient water users. Mr. Williamson, who is representing a number of the owners there, does discuss infrastructure. In regard to infrastructure, the submitters have concerns as to how the infrastructure will be proposed in the Plan Change 68 area and how it will be funded. The submitters are represented by Mr. Williams, who, while having very limited experience in Selwyn or in Prebbleton, raises an interesting point. The rollout of integrated infrastructure in the Selwyn district is one of the most successful in the country. The methods used have been a key reason for Selwyn being one of the fastest growing and progressive councils in New Zealand. The basis for most situations, such as the proposed PC 68, is a collaboration between developers and council by way of development contributions or a private developer agreement. These are, of course, mechanisms available to the council under the Local Government Act. In some instances, the council will pay for infrastructure projects by including them as capital expenditure in the LTP, and then recovering the cost by way of development contributions paid by the developers. This is the case for a raft of growth-related expenditure, including the council's current LTP, including upgrading of roading infrastructure required as a consequence of the establishment of the Southern Motorway, and also upgrading of the wastewater treatment plant to double its capacity in Rolleston. On other occasions, the council and developers collaborate in a private developer agreement where the developer constructs the infrastructure and the council reimburses the developer for any upsizing, i.e. the provision of additional capacity beyond that required by the individual development. The reimbursement payment is made by council at the time of 224C. Those council costs are recovered at the time of future development, whilst the developer is temporarily absorbing the cost of the infrastructure upgrades. He is happy to do so, as it allows work to progress development rate rather than a rate dictated by council funds. Ultimately, however, the developer still pays for the infrastructure. These agreements are created at the time of subdivision when the extent and cost of the infrastructure is known, as opposed to the time of zoning. This is entirely appropriate, as there is often a delay between zoning and the approval of subdivision, during which time the cost of infrastructure may increase and developers' plans may evolve. In all cases where I've been involved, the detailed engineering designs are completed and the tendered prices are obtained before the agreement is signed. By doing this, the council is guaranteed as to the actual costs. This work can only occur post-subdivision consent. These methods have been used successfully for many years in the Selwyn district, and I don't see any reason why they can't continue. I personally have been involved in multiple developments around within the Selwyn district where infrastructure has been funded by either of the mechanisms discussed above. I'm not aware of any situations where these mechanisms have failed. Recent examples involving large development include Farringdon and Rolleston, Barton Fields and Lincoln, Wheelfield and West Melton, Rosemary and Lincoln, and many others. The three applicants in PC 68 are all highly experienced developers in the Selwyn district. They will continue to work with the council to ensure that the proposed infrastructure is efficient, integrated and robust. Added to this, the Selwyn District Council is well funded and progressive by nature. They do not suffer the financial burdens of other councils, and this allows some freedom for the better strategic rollout of services. I have no concerns as to the installation of infrastructure in PC 68 and believe that it is easily achievable with using methods that are well practiced and successful in the Selwyn district. Mr. Williams, in a practical sense, unfounded. And finally, Mr. Langman's submission. A key point raised by Mr. Langman in terms of infrastructure is his query into how the proposal may address the proposed medium density residential standards. This is a very relevant issue to all urban land. New development is perhaps better suited to deal with this, but the real issues will become more impactful for existing infrastructure. The concept of placing enormously greater demands on existing infrastructure does not appear to be well conceived. It is, in my opinion, that the effects of this potential legislation will need to be addressed in a forum far greater than this respect. For the purposes of this application, the infrastructure capacity will be dictated by council and the development will be formulated to suit this. Simply asserting that all land can become medium density does not factor in the practical matters of servicing, such as the size of pipes be used to connect into public infrastructure and many other assets.
Thank you, Mr. Hall. First of all, in relation to the question of the potable water supply, and Mr. Chen's concerns about the purity of the water, I'm not sure where his water is obtained from, but would there be other confined aquifers there, or?
I agree. I'm not entirely sure where his water is obtained from, which level. But
so if it's within a confined aquifer, then the discharge of stormwater would presumably not influence the purity of the water in the confined aquifer. Is that right? Because the stormwater couldn't get into the aquifer.
That's correct. But there is other water.
But we don't know the situation at the moment.
No. Stormwater is derived from everywhere. We should think about Mr. Chen's property as being to the west of this development, and stormwater entering into the aquifers will grade towards the east, so they will be falling away from Mr. Chen's property.
But just thinking that through, that would be a permeable aquifer, wouldn't it? The one you're talking about, i.e. that the stormwater can permeate through into the aquifer. And if that were the case, what would be available to what would be available to Mr. Chen? You say the council will look after it, or the regional council?
Yes, the regional council have a number of standards required to meet specific potable water issues, and if there is they believe a treatment required, then we'll impose that upon us. But in most cases, the percolation of stormwater through 5 to 10 metres of gravel will easily clean that stormwater.
If the water's not treated at the moment, and I don't know, and he doesn't want it treated, is it possible to go through to a confined aquifer to obtain water? Do you know enough about the underground structure in the subject site to know whether that would be possible?
I can't be specific about that site, but I would virtually guarantee that if they went deep enough, you can find an aquifer which would be suitable, as is the case right across the Selwyn district. But I think what he would probably do, if he was very concerned, would be connect to the water supply.
So you think he could go to a confined aquifer or not?
Yes. But he does have the ability to connect to the Prebbleton water supply.
I mean, the reason I say that is because he may not be happy about having the water treated if it wasn't of the right.
Yes.
I think one of the main concerns expressed by the submitters is that there's been a lot of talk about the adequacy of the infrastructure, but not enough certainty about when things are going to happen. In particular, looking at your talking about the wastewater pump station, before approving this change, would I need to be satisfied as to the timing of the construction of the pump station?
No, that becomes part of the development. There are occasions where a subdivision consent condition will require that capacity to be available prior to 224C. And quite often is the case that the developer will take on the role in constructing that infrastructure, that key infrastructure, by way of PDA.
So it's dealt with at the subdivision stages or what?
Mhm. Yes.
In other words, what you're saying is that if it were to be approved, couldn't go past that point without this being satisfied, without the wastewater. If the pump station was needed, the pump station would have to be in before they could proceed any further in the subdivision stage.
In the titling process, yes. So
In the what process?
in the titling process, so we wouldn't be able to obtain the 224C certification prior to having that infrastructure in place. But that's purely a subdivision matter. I might add to that, I'm very confident of obtaining that capacity.
But it does seem, am I right, it does seem that a new pump station will be required, or a new pump station will be required, is that?
Yes, absolutely. So there'll be a new pump station on site and there'll be upgrades, and that will pump to the Prebbleton main pump station. And there'll be some minor upgrades to that pump station along with some upgrades to the rising sewer pipe.
Just so I've got it clear, the Pines, it all ends up in Pines, doesn't it?
Mhm.
Is that Pines treatment, wastewater treatment plant, is that running at capacity or near it, or has it got plenty of capacity?
It's got plenty of capacity at the moment, and that capacity is about to be doubled, or they're in the process of doubling it.
And you say when it's about to be doubled, when's that?
I can't tell you the exact timing. Obtaining the correct consents is a dangerous business to try and predict, and it's purely being done by council.
So anyway, you're saying it's got capacity enough now, so why are they doubling it?
We're currently working on other projects. We're looking at dealing with the pumping of wastewater from Darfield and Kerwee back to the Pines. Both of those townships are currently on septic tank. In fact, Darfield's the largest town in New Zealand still on septic tank, so there is quite a good environmental reason for expanding that treatment plant.
So with the doubling and with Kerwee and Darfield coming on stream, are you saying there's plenty of capacity?
Absolutely.
Yes, thank you, Mr. Ward. Thank you, you're free to go. It was 1:05, I think we might have a break. Is everyone happy with that?
We're one witness behind. I think that's pretty good.
Oh, that's not too bad. I'll soon catch that up, I think. So, 1:45? What time do we schedule? Maybe a bit long, won't it?
Too long? Too long?
Can't find my program.
It's 1 to 1:45.
Yeah.
Oh, okay.
Yeah.
So
We have,
I'm relaxed about it. We're making reasonable progress. Should we say 150? How would that be? That give you enough time?
so we have 3 witnesses here.
Okay, we'll say 150.
We certainly get finished today.
That's fine. Thank you.
Thank you.
150? The matter I just want to raise, and that is that Mr. Williamson is unwell. He's not able to give evidence tomorrow. And he and those that are under his umbrella, so to speak, have requested that they be heard on Monday next. Now, time is available on Monday next, and my inclination is to schedule that part of the case until Monday next. Are you available then, Mr. Perry?
I'm almost certain I am, sir, but I can confirm that.
Has anyone else got a particular problem with that? As I see it, I can't hear them tomorrow because Mr. Williamson is not available, and it appears that Mr. Williamson, that the other submitters want to be with Mr. Williamson when he's here. So the sensible thing seems to me, subject to anyone else having any difficulty, the sensible thing seems to be to schedule it here next Monday, but on the basis that the reports from Mr. England, Mr. Collins and Mr. Cleese follow that, because it seems to me that they should be reacting to all the evidence that's been given before, and that I'm a bit uncomfortable about them giving their reports before all the evidence has been given, in case there's something that arises which may impact upon what they're saying. Is there a problem with that or not? In other words, we finish the whole case next Monday. There'll be a full day on Monday. There'll be effectively Mr. Williamson and those he represents, so to speak, and then followed by Mrs. England, Collins and Cleese, and then tomorrow we just carry on with all the other submitters tomorrow, and then probably there's being an attempt being made now to reschedule Mr. Chen and others so that they be brought forward.
Yes.
Which means that we'd have probably tomorrow, we'd probably finish around about the middle of the day tomorrow of the submitters, and then the next day, where am I? Tuesday, Wednesday is, so that those that are scheduled for Wednesday would then be follow Mr. Williamson and the others on Monday. Now that's my intention at the moment, but I want to hear from anyone of any particular. Do you need to check on that?
I've just checked that down. There's a couple of things I can do. So.
Okay, well, let's just leave it at that at the moment anyway. That's the present state of matters. So now we've got a schedule. So that covers the schedule, I think, doesn't it?
Thank you, sir.
Right. Mr. Smith.
Yes, thank you. I'll get a summary statement. Yes,
I should have asked, has anyone else in the rear of the hearing room got any problems about what I've just said? Yes, thank you. Just like to read your evidence. Thank you.
Great, thank you. I'll start at paragraph 2.1.
Yes, thank you.
I have prepared an integrated transportation assessment to assess the potential transportation-related effects of the proposed rezoning.
Sorry, you just speak up. They can't hear on the back. You're speaking softly. I have to turn it off.
Oh, that could help.
Is it on?
I may not be the technical support person you're looking for. It doesn't have a light or anything like that coming
No,
on.
it doesn't have a light. We just hit the end.
No.
I can bellow if that's helpful.
I think we'd rather do it the other way, but don't we?
Might lose my voice.
Right.
So if that is the sort of people watching, can hear what's
Yeah.
going on.
The people watching as well.
Oh, of course.
Can't see all here.
Don't know why. It's not working.
Just like a little flat battery, is it?
No, it's saying it's on, it's just not
It's
actually.
just trying to be difficult, isn't it?
Yeah, like everything this morning. No, it doesn't seem to be working. If you make a start and just raise your voice, I'll find some more batteries.
Thank you.
That's a shout. Speak very loud.
I'll do my best, sir. I have prepared an integrated transportation assessment to assess the potential transportation-related effects of the proposed rezoning on the future transport network. This included a transportation modelling assessment of the plan change traffic, which demonstrated there is sufficient capacity on the transport network to accommodate development traffic, with future intersection upgrades in the vicinity of the plan change anticipated by Selwyn District Council and included in the long-term plan. My assessment also identified that the plan change site integrates well with the Prebbleton and wider transportation network and seeks to maximise connectivity and accessibility for all modes, including walking and cycling. I have also concluded that plan change 68 is well located to be directly serviced by public transport and has the potential to integrate well with the future public transport network, maximising opportunities for uptake of sustainable transportation modes. I have reviewed the strategic planning framework and consider that the plan change is consistent or can be consistent with the relevant transport-related provisions. I have concluded that the plan change can be supported in relation to transportation matters, and any effects associated with the plan change are appropriately mitigated or anticipated by the long-term plan. I have reviewed transport-related matters raised in submissions and have concluded that any concerns raised are adequately addressed through the plan change. I have addressed the questions raised in the Section 42A report relating to the staging of the development through an additional transportation modelling assessment. I have subsequently recommended that 120 lots can be established at the southern end of Plan Change 68 as an initial stage of development directly connecting to Guinea Drive and the southernmost Hempdons Road access, shown on the ODP. This initial stage can be supported following the construction of the Shands Road, Trents Road roundabout, with the remainder of the development to follow the completion of the Shands Hempdons roundabout upgrade and Trents and Hempdons Road seal widening projects. Mr. Collins notes that the Shands Trents roundabout included in the long-term plan is intended by Council to be a single-lane roundabout. I have modelled the future performance of a single-lane roundabout at this location and concluded that a second approach lane is required from the Shands Road northern approach. And I note that this is a matter which I will revisit again later in the summer. Mr. Collins makes several recommendations for minor changes to the ODP, including provision for cycling within the plan change site and upgrading the Hempdons and Trents Road frontages to include footpaths to connect with existing footpaths on Hempdons Road and Trents Road. And just to be specific, Hempdons Road, I do support the extension of the footpath from the frontage through to Farthing Drive, which was a matter that was raised in Mr. Collins' report. I support these recommendations and have advised Ms. Hart that I recommend minor amendments be made to the ODP accordingly. And these have been done. Subsequent to the lodgement of my evidence in chief, I have received feedback from and engaged in several discussions with Mr. Collins and Mr. Maisie from Selwyn District Council regarding the proposed enhanced roundabout configuration noted above in paragraph 2.7. So that's the Shands Trents Road roundabout, sir. Mr. Collins has raised concerns about the level of delays in the morning peak period on the Shands Road southern approach heading towards Christchurch. Whilst I remain of the view that the configuration presented in my evidence in chief provides satisfactory level of service in both the morning and evening peak periods, I agree that there is an opportunity to deliver further benefits to existing and future road users and to further future-proof the roundabout. I also acknowledge that the addition of Plan Change 68 traffic results in an increase in delays on the Shands Road southern approach in the morning peak from 7 seconds to 30 seconds. I consider that this increase in delay can be offset by further enhancements to the roundabout, specifically the provision of a second approach lane and a circulating lane for northbound through movements on Shands Road. This approximately doubles the capacity of the northbound through movement, with the resultant intersection configuration shown in figure 1, which is just on the next page. The additional approach lane from the north for left turning traffic into Trents Road, as proposed in my evidence in chief, has also been retained. And I've specified those improvements on figure 1. I have undertaken transportation modelling of the Shands Trents Road configuration shown in figure 1 using Sidra intersection software. The modelling methodology and assumptions are otherwise consistent with and comparable to those presented in my evidence in chief. A summary of the intersection delays for each approach and intersection level of service is presented in the table below. The columns with the enhanced figure 1 layout are highlighted in bold text and compared to the layout presented in my evidence in chief and the base case whereby a single lane roundabout is constructed, and that is in the absence of Plan Change 68 traffic. Moving to paragraph 3.5. The results demonstrate that the updated enhanced layout from figure 1 reduces morning peak delays on the Shands Road southern approach from 30 seconds to 8 seconds. The overall performance of the intersection is comparable with the base case, that is with a single lane roundabout and no Plan Change 68, with very low intersection delays and excellent level of service. I have advised the applicant team that I support this enhancement, which will deliver benefits to Plan Change 68 traffic, as well as wider benefits to existing and future road users in the vicinity of the site. I understand from discussions with both Mr. Collins and Mr. Maisie that this updated layout is acceptable to council, and preliminary scoping and design work is already underway at the instruction of council at the time of preparing the summary statement. I further understand that the applicant team is now working with council towards a developer agreement to deliver the improvements shown in figure 1. I'll now move to the review of submitters' evidence. I've reviewed the evidence prepared by submitters and note that no new technical transportation evidence has been presented. Of note, Mr. Langman's evidence prepared on behalf of Canterbury Regional Council and Christchurch City Council addresses transportation-related policy matters in paragraphs 134 through 145. Mr. Langman in paragraph 136 states that Christchurch City Council is concerned about the current reliance of Prebbleton on Christchurch for employment and notes no employment is included within Plan Change 68. Prebbleton is located in close proximity to 4 key activity centres, being Robertson, Lincoln, Hornby and Hallsville. These centres all offer employment, retail and commercial services and are located 11, 7, 6 and 7 kilometres from Plan Change 68 respectively. Mr. Colgrave has supplied me with business demographic data from Statistics New Zealand, which is included below in Table 1. This shows that employment in the Hornby and Hallsville areas has increased by 52% in the past 10 years, compared to 12% for the remainder of Christchurch City. In the last year alone, there has been continued 3% growth in employment in Hornby and Hallsville and a shrinkage of 2% in employment elsewhere within the city boundary. This demonstrates that whilst Prebbleton residents may be reliant on Christchurch for employment, there is significant and an increasing quantity of employment within 7 kilometres of the plan change site. And Prebbleton residents, including potential future residents of Plan Change 68, are not necessarily reliant on long distance travel across the city for employment. Mr. Langman raises concerns about cumulative downstream traffic effects, including Plan Change 68, despite the comprehensive modelling assessment undertaken by QTP and conclusions drawn by Mr. Collins on behalf of Selwyn District Council, which I accept and address in paragraphs 12.8 through 12.12 of my evidence in chief. Mr. Langman also raises the matter of medium density residential standards and states there is no indication that the implications of these standards have been taken into account as part of the transport modelling. I have reviewed the QTP modelling report, which is appended to Mr. Collins' transportation hearing report, and note from Appendix A that Scenario 2, which is the scenario relied upon by Mr. Collins to understand the cumulative effects of plan changes across the Selwyn district. It includes 10,049 households developed between 2018 and 38, which is consistent with the full development of the plan changes listed in Appendix A. These 10,049 households have been included in the model over and above the Statistics New Zealand medium-high growth projection, taken from Statistics New Zealand subnational population forecasts for the 2018 to 38 period. This equates to 9,105 households in the portion of Selwyn district located within the model study area. This means that the network model testing is highly conservative in that it considers a scenario which is more than double the anticipated growth forecast to occur within the district. I have 22 years of transportation modelling experience and have worked with the Canterbury transportation model used by, that should be QTP, not WTP, my apologies. So I've worked with the CTM, which is used by QTP for this testing since 2016, including the development and testing of land use scenarios. Based on my experience in using the CTM, I am aware that the allocation of the 9,105 households within the CTM model over the next 20 years to align with the medium-high growth scenario is made up of a combination of greenfield and infill growth, with both being included in the model. The adoption of the growth forecast from Statistics New Zealand and subsequent allocation of that residential growth to greenfield and infill areas is consistent with transportation modelling best practice. On this basis, there is already an allocation within the model in the QTP report for infill development such as would be enabled by the standards. The Scenario 2 modelling assessment presents the cumulative effect of both greenfield and infill development to match a medium-high growth forecast, as well as 14 private plan changes, delivering a further 10,049 households. I consider this to be an extremely conservative scenario, which provides confidence that, as Mr. Collins states on page 8 of his report, Shands Road and Springs Road are expected to experience little change in forecast traffic growth when comparing a 2038 scenario with 10,000 additional dwellings in forecast. I further note that not all of the plan changes that have been heard to date have been recommended by independent commissioners to be granted. So the 10,000 households included in the assessment is an upper limit on the cumulative land use growth forecast and resultant cumulative transportation network effects. Mr. Langman states the plan change site is not currently serviced by public transport, with the nearest bus route being located 1 to 2 kilometres away. Access to public transport is a matter that I address in paragraphs 1219 through 1222 of my evidence in chief. Simply put, there are no adjacent public transport services as the plan change site is currently predominantly rural and does not have the density of land use activity to currently support public transport. However, should the plan change be approved, there are options to redirect existing services or to provide new services through and adjacent to the site. Plan change 68 does not preclude any such services from being established and has been specifically designed to accommodate the future movement of buses along the primary road within the ODP. I fully expect that the central primary road shown on the ODP will be designed to the Council's required engineering standards and will therefore be able to accommodate buses. It is possible to identify on the ODP an indicative location for a bus stop and to include supporting text within the movement network section of the ODP to reinforce a requirement that the design of the primary road facilitates public transport. I agree with the principle from the Regional Public Transport Plan included in paragraph 142 of Mr. Langman's evidence that, and I quote, the integration of public transport and land use planning is essential to managing population growth. As Greater Christchurch develops, including the establishment of new growth areas, there are mechanisms in place to regularly review bus services, either through regular service reviews initiated by the Regional Council or through requests made by the public. As Prebbleton and other Selwyn towns grow, I would expect several new services to be established to integrate public transport with land use growth in much the same fashion as the Burnham to Lincoln service, Darfield to Christchurch via West Melton, Southbridge to Lincoln, and the Rolleston to Christchurch Express Park and Ride services. All of these services have been introduced in recent years in response to growth within Selwyn District and demand for public transport. I remain of the view as stated in section 11 of my evidence in chief that the plan change is consistent with the relevant regional and local transportation policy documents. To conclude, based on my assessment of effects in the ITA and following consideration of submissions, section 42A report, additional modelling presented in my evidence in chief and summary statement, and evidence prepared by submitters, I am of the view that the plan change can be supported in relation to transportation matters. Thank you, sir.
Thank you, Mr. Smith. Looking at paragraph 2.4, you talk about the Selwyn District long-term plan. Is that the appropriate, the instrument which governs what infrastructure is to be, is envisaged in the years between there 21 and 31? Is there any other instrument besides that one that we should be looking at?
No, that's the instrument for infrastructure that is being delivered by Selwyn District Council as a road controlling authority and in their other capacities, obviously. And it also links back to the development contributions policy. So the items that council are collecting DCs from developers are itemised within there, including the proportion which is allocated to DCs.
Right. You see, one of the matters that's been raised by submitters is, well, look, we'll talk about infrastructure, but there's a lot of this will happen in the way that things being put forward at the moment. And they would say lack of certainty as to the outcome. For example, let's just have a look at some of the issues here. In terms of the Shands Trend Road roundabout and the Shands Hamptons roundabout and the Trents and Hampton seal widening projects, what if approval is given to this change? Wouldn't I need to be satisfied as to when that's going to happen?
I think it's very relevant, and so my position is that the Shands Trents roundabout does need to be in place. At the moment, the delays for right turners out of Trents Road and Hamptons Road onto Shands Road are quite lengthy during peak periods.
So the Shands Trent is the first one, is it?
That's the first cab off the rank. I would suggest that, well, that is a certainty. Wakatahi has approved funding towards it for their funding share.
So why is it certain?
Both Wakatahi and Council have approved their funding shares towards it, and it is currently going through a detailed design process. So I expect that would go out.
And you say that your amended design with the second main bypass, etc., has been approved as well, or not?
I've had verbal agreement from Council that they accept that improvement. It would clearly need to be tied into the plan change to an extent. The applicant team, I understand, are already talking with Council, so some open dialogue has started there around how that could be delivered. But the design work is already done.
And what about Shands Hamptons? About?
So Shands Hamptons is currently scheduled for 2023, 2024. So it fall into the next financial year after the one that we're moving into. I'm not aware of any specific design work going on with that beyond the fact that it's intended to be delivered as a large dual lane roundabout.
Just on that point, is there a mechanism? You may not have been here when we were talking about infrastructure, and there was the question of whether or not the pumping station was going to be constructed, and the answer to that was, well, you don't get a 224 certificate, and you can't progress further unless they're satisfied about the council satisfied about that. Is there something like that in the context of these improvements or not? Are they linked to any certification, later certification beyond actual approval of the plan change or not?
Not that I'm aware of, no.
So what say, I suppose I've got to look at the question of, well, what say the council changes its mind or doesn't go ahead with, for example, Shands and Hampton roundabout?
Well, my position, I think I've stated this pretty clearly, is that a proportionate development could be accommodated by the wider transport network. And I've undertaken testing of 120 lots. Beyond that, I consider that Shands Hampton improvement or some form of improvement at the very least is required to be able to address delays at that intersection.
And does that apply to the seal widening and Trents and Hamptons or not? Is that seal widening?
The seal widening, they are included in the LTP as separate line items, but my understanding is that they would get delivered at the same time as the Shands Road roundabouts.
Shands, Trents roundabout.
So the Trents Road seal widening would be delivered at the same time as the Shands Trents roundabout. And the Hamptons Road widening would occur at the same time as the Shands Hamptons roundabout. That's my understanding. They are programmed for the same years as the roundabout upgrades.
So Trents comes first.
Yes, it does, yeah.
And then Hampton, followed by Hamptons.
Yep. And they'll be more in keeping with an emerging urban environment such as would occur if the plan change were approved.
Right, well, that's something I have to consider. So I just didn't hear what you said on 4.8. You made, wasn't WTP, was it there?
No, that's QTP. Q for quality.
Q.
I actually had another correction to my evidence in chief that I forgot to mention before.
Yes, right.
If you have a moment. Paragraph 12.42. And it's item B under that. Yes, certainly. It's the top of page 27, if that's helpful.
Yes,
This relates to the very matter we were just discussing. In the fourth line on top paragraph, page 27, that should read Shan's Hamptons roundabout, not Shan's Trents.
thank you for that.
You're welcome.
Now, I suppose the same question arises in relation to public transport, with the evidence that the bus services are sort of quite a long way away from the site. And what you're saying is, well, witness the fact that there have been 2 new routes put in relatively recently, that you would expect an examination of this to take place. When would that take place, the bus route examination? How would it be accomplished?
So it can occur in one of 2 ways. Firstly, it can be the initiative of the regional council. They undertake regular route reviews. I will apologise, I don't know how frequently that is.
Yes.
But as the urban area develops, they will be looking for opportunities to provide better service across those areas. So that's one mechanism. The second mechanism is that it could be initiated at a request from the public. Should they wish for public transport services to be established, they would make a formal request that the regional council could look at that. They'd undertake their assessment, and there are mechanisms there whereby council could set up a public transport service for the area, and it may also include targeted rates to be able to help subsidise services.
Right, so when I'm dealing with this, I have to deal with it, don't I, on the basis that the services at the present time are as they are, some distance from the site, but that there is a prospect that they may change, but I can't be absolutely sure that they are going to change. That's the point, isn't it?
You can't be absolutely sure, but this isn't a case of the chicken or the egg. The development would lead, the public transport services would follow. So it is a process which is well ingrained to be able to undertake these route reviews and to provide better services for the public. So I think you can have confidence that the regional council would look at it as the area develops. And I think there's evidence of that with the list of services I mentioned there in my summary statement, some of which have been delivered through targeted rates, such as the Darfield West Mountain service, and others which have been added on by regional council to meet demand.
So some of it's funded by the regional council, some by private rates.
Correct, yes.
Does there any sort of rhyme or reason as to which one it is? Or?
My understanding is that if the regional council were to look at a particular proposal for a public transport service and it did not meet their criteria in terms of economic thresholds, they may go back to the community and say, what are you willing to pay? And
that comes back to it goes back to a rate funded basis.
Correct, yes. And
but the rates are paid to the regional, you mean part of the regional council rate?
Correct, yes.
So in other words, what you're saying is that someone getting that it's either funded without the need to go to a regional council rate, or if they say, well, it's economically not feasible, do you really want it? Then they may say, all right, well, but we're going to impose a rate.
Yes, there are those 2 avenues that can be explored.
You're talking about the Trent's Shands roundabout. I mean, I think Shands Road's a pretty busy road, isn't it?
There's about 14,500 vehicles.
I don't really know. Is that regarded as busy?
It's an arterial road, so it is busy. It's not running at capacity, but it certainly is a busy corridor.
So before your planned intersection improvements, which provide for the second sort of flow through lane, so to speak, at the back, so you can go, you're going down Shams, you don't have to, you can actually, you don't have to wait for the car in front, that bridge, you can go around the side, that's the whole point, isn't it?
Yes, it is.
That's right, yeah. And then you made the point that that would reduce the time from 30 seconds to whatever it was.
Down to 8 seconds.
Is 8 seconds. Now, looking at it at the 30 seconds, would there be any sort of element of danger if we have the 30 seconds and you're just waiting for that gap, are you? I mean, they're not arriving all that often, the gaps in the traffic, is that what the 30-second one's about?
Yes, it is. So it's a flow-based model where you're identifying how much flow is coming in from that particular approach, how many vehicles are opposing them, and looking for the gaps in between. So by distributing that traffic across 2 lanes as opposed to 1 lane, it creates a wider pipe, if you like, for that approach traffic to be able to move through the intersection.
But leaving it without the improvement and looking at the 30 seconds, would there be a significant element of danger in that or not? I mean, would there be more accidents expected there, or any significant number of accidents expected there or not?
Well, one of the catalysts for these improvements is to also improve safety, not just efficiency. So by constructing a roundabout as opposed to the current priority control configuration, you've got a geometric design there which actually slows vehicles down prior to reaching the intersection and then slows them down as they manoeuvre through the intersection. So
it slows the Shandsbury traffic down because they see it in front, they just slow down a bit, they come into the roundabout.
Yeah, absolutely. And that's part of the geometric design considerations of the intersections to make sure that vehicles cannot actually manoeuvre through at speed that would still have an inherent safety risk.
Yes, thank you, Mr. Smith, thank you. Ready to go, thank you.
Thank you very much.
I'd like to read it in first, thank you. Just, I can't speak into that speaker, but just make sure it's working.
Okay. My name is David Compton-Lyon, and I prepare to state that evidence on behalf of Urban Holdings Limited, Urban Developments Limited, Canberra Developments Limited, dated 8 March 2022, which my qualifications and experience are set out. I'm of the opinion that proposed plan change, private plan change to rezone plan change 68, aside from rural inner plains living Z zone as an extension of existing residential settlement in Prebbleton, is an appropriate use of the land from an urban design and landscape perspective. There's a typo in the sentence actually. The Prebbleton structure plan is now fully implemented, with all the growth areas having been completed. Prevail's final stage is currently under construction with all lots sold. Proposed plan change proposes a minimum density of 12 households per hectare. This is higher than the recommended density in the operative district plan township objectives and policies for the living Z zone, but is considered appropriate for Prebbleton, not Boston, to meet the outcomes desired by the NPS UD and policy 4.2.10 of the Selwyn District Plan to achieve a well-functioning urban environment while not precluding high-density development if required in the future. The plan change will enable a range of housing typologies and densities provided for to ensure choice for the community and to cater for population growth and changing demographics. The plan change is a logical extension to Prebbleton. With the proposed ODP, the proposal will create a well-functioning urban environment. In terms of landscape character and values of the area, subject to the mitigation measures proposed, the proposal will result in an acceptable magnitude of change on both the existing rural residential landscape character and values. Both Trents and Hamptons roads form natural breaks for a zone change, recognising that there will be a change in character, but this is not necessarily a negative aspect. In terms of visual amenity, the adjacent rural residential properties will experience a change in the openness of views across the space, although in many locations views are restricted by either existing shelter belts or plantings. Adjoining suburban residential properties, current and future, overlooking the plan change areas will have a mix of open, partial and screened views of future development. Changes to the experience of these residents is considered low given the character of existing views and existing boundary treatments of their properties, with the plan change viewed as a natural extension of existing residential areas. I am in agreement with the Council's Section 42A report by Mr. Jonathan Cleese that the block ordered by Hamptons, Trents and Shan should be included in the rezoning. This avoids mid-block zone boundaries and allows for a more integrated, cohesive approach. It does not force existing owners to intensify, but does not preclude development happening in the future. The evidence of Mr. Nick Williamson. I've read his evidence and would like to note in particular his paragraph 37, where he concludes that there is a disconnect between the ODP and good urban design outcomes. The ODP provides a connected hierarchical network of streets, open space provision, and a network of shared paths. The ODP also allows for a variety of housing typologies to cater for growing residential population. All of these aspects are recognised as key urban design outcomes, i.e. achieving connections, choice, custodianship, and context as higher level attributes. Aspects such as character, creativity, and collaboration are picked up at the subdivision stage, where it is possible to analyse the development enabled by the zoning at a more refined level of detail, refined level of design. Aspects such as fencing, the placement of open space, and what activities are proposed in that open space, the design of tertiary streets, all of which add to the character of a settlement and are important, but I do not think these should be prescriptively determined at the ODP stage. They just need to be recognised so they can be captured at the next stage of the process. Happy to answer any questions concerning my evidence or the proposed ODP and accompanying text. Thank you.
Some planners like to see a sort of a gradual movement from high density housing, the sort of housing you see in Prebbleton at the moment, moving into larger urban, sort of larger lots, including lifestyle lots, and then sort of with the farming community. But is that really a practical option in most areas like this or not? In other words, having that rather structured gradation from concentration to, let's say, the larger lot strokes, lifestyle lot to the open.
Yeah, I think, 10, 15 years ago, there was probably the thinking, but I think thinking has changed in that the importance is that we don't want to preclude future growth and future connections. I think the benefit with the ODP process is that it allows us to identify those connections through spaces in an integrated approach. There is a risk with those larger lifestyle sections, and I think we'll find that in parts of Prebbleton that it will be difficult for those to intensify in the future, just because of the ownership structure. Some people will sell, some won't, but it will be difficult to get those connections through. And that's the beauty, I think, of this Living Z, that it allows for a diversity of housing typologies, but it really does get those links.
But in this, we're talking about a minimum of 12 per hectare, aren't we?
Yes, and so I think if that increased to 15 or 16 or wherever.
You're not talking about diversity in terms of there being, say, the old lot that's a lot larger, for example.
Well, I think that could still happen, but over time, you sort of look at areas like Prebbleton and Maribel, where there is movement within boundaries, people consolidate sections, and they buy the neighbour's property.
When you look at this aerial photograph, this very helpful aerial photograph, you can see that there's a large number of lifestyle blocks to the north of this block, aren't there?
Yes.
And to the what is it, south, well, not south, up here, the Prebbleton side, relatively high density, and then immediately adjacent to this block, you've got these lifestyle blocks, quite large blocks, some of them not, I suppose, some of them are just large blocks, and some are lifestyle blocks, I suppose you'd say property so cool. But do you see any difficulty about the fact that you're moving, I suppose, from the high density to the sort of development I just talked about, and then another sort of high density development here? Is there something in that shouldn't be there, or what's your view of that? You probably expressed it, but I just want to hear it.
No, I don't see an issue there. I see this development very much being a natural extension of the existing areas of Prebbleton. At some point, there's always going to have to be an edge where the urban meets the rural, but I don't think by providing buffer lots or larger lots is the right approach for current thinking. I think a lot of these developments and plan changes about providing greater housing stock, and so I think that has to be a key driver, I think.
Well, I think you said before that idea that I was noting that I understood may have been in existence, i.e. the idea of an ideal situation where you go from high density to the lifestyle stroke, larger lots to the open. You said that was really a thing of the past. When did that change?
I think it's probably only the last 10 years, and I think it's probably
why did it change?
I think potentially because it quite often doesn't work. The market drives aspects of it, and as you start to
So the market dictated that it didn't like it.
Well, didn't like it, but it doesn't. It quite often won't result in good urban form, because towns grow. They just naturally grow out, and so if you put an artificial edge in there, the town then has to jump that edge. So whether that edge is the rural residential development, it can work with greenfield, so with green belts and open space. But I think once you get into rural residential development, it's almost urban by nature anyway.
So you're saying that the higher density has to jump the lifestyle stroke larger lot if the town's to extend. Not in every situation.
No, but and you could also rezone the rural residential, the larger lots, into a more intensive zoning, but it's difficult because everyone wants to develop at different stages, and if the connections and the links are there, then it's relatively straightforward. It's just where yes, you look at the Mandeville areas where you have a lot of, realise it's a different district, but there's a lot of long cul-de-sacs, sort of 5,000, 10,000 square metre sections, but it'll be very hard to retrofit.
Well, we're looking at this here. I mean, you go down Kingcraft Drive, for example, and look on either side of that. They're the larger lots, aren't they? But there's a fairly high standard of housing, isn't there?
Yes.
And so you wouldn't expect, with that I wouldn't have thought, the idea that they're suddenly going to say, well, look, well, let's forget about that. Let's go for a much more dense type of development there. Wouldn't it be unlikely? I would have thought, I'm asking your view, would it be likely to happen in that area, in that sort of general area?
Not in the short term. It may happen in 30 years or 20 years. I don't know, but I guess the key aspect is that we don't want it to preclude it happening.
So it's not likely to happen now, but it could later on.
Yeah.
Because things change.
Yes.
In paragraph 4, you talk about Rolston. Was that intended to be Rolston?
No, that was a typo, sorry.
Sorry.
Same principles, but yeah, different.
So you've got the impact of the new legislation, I can call that on the objectives of policy, the operative thing.
Yes.
Yes, thank you very much. Thank you.
May have caught up, sir.
Should we have a bit of a break now? Do you want to do that?
Oh, no. We have final readings this time.
Thank you.
You've got your summary.
Right, the following summarises my evidence as well as commenting on some of the additional matters that have arisen in the planning evidence of submitters. Plan Change 68 is a request for rezoning of land in the southwest Prebbleton for residential purposes. No new provisions are proposed or sought other than a change to the planning maps and the inclusion of a specific outline development plan and associated policy to apply in the land to be zoned. That's Mr. Williamson made reference to the fact that we actually are putting a policy into the plan. That's because all ODPs have a related policy that sits in the subdivision section of the Selwyn plan. In my opinion, Plan Change 68 is a logical planning response to provide for the growth of Prebbleton to enable more housing to meet existing and future demand. In recent times, there have been numerous assessments of demand and available capacity for housing by central, regional and local government and the Greater Christchurch Partnership, economists and property analysts. In relation to Prebbleton and indeed other centres such as Wollaston and Lincoln, many of these assessments for the short to medium term have underestimated demand, which has increased despite earthquake demand being very largely fulfilled. Until relatively recently, Prebbleton has been able to provide medium-priced sections, enabling hundreds of new houses to be established. This has been positive for the population of Greater Christchurch, especially those in need to relocate after the earthquakes. The economic assessments prepared for the applicants and the evidence from Mr. Sellers conclude that there are now no available sections for purchase, and therefore there is a significant unmet demand in Prebbleton. This means that the short-term demand up to 3 years cannot be met, let alone the medium-term 3 to 10 years. This shortfall has resulted in significant price increases, making sections in housing increasingly unaffordable for many people and households. And I can mention that that has a flow-on effect all the way through to people who are renting and not being able to get any premises at all. To date, the various planning regimes have been lagging in responding to this issue, with no new zonings being proposed for Prebbleton or the Selwyn district. I therefore consider PC 68 as a positive step forward, enabling an extension of the Living Z zoning in southwest Prebbleton. The Plan Change 68 site is well suited to provide for an extension of residential zoning in Prebbleton. In particular, its location ensures that the Prebbleton residential area can extend southwest, noting that to the east of Plan Change 68 it adjoins Stirling Park, which is now a fully developed residential area sitting between Hampton, Springs and Trents. Connections with Stirling Park and new residential development to the west, such as PC 68, have already been planned and created in the form of connecting roads, which is Gilder Drive, 2 green space cycle routes and a further road through Guinea Place. So clearly, development on the site of Plan Change 68 was planned for some time ago when Stirling Park was being developed. To the west is Shands Road.
So, of course, there, just looking at this, where can you just perhaps just approach me and just tell me where we are? Stirling.
Right, so this is all Stirling Park. So this is on the end of the block.
Yeah, I'm not so sure.
So you've got
Stirling Drive now.
You've got that road, you've got several green linkages as well.
Oh,
So there's 3.
Stirling Park's a whole.
That corner, this way will.
You'll know presumably where Stirling Park is.
It's all named after Monday, you see.
That makes it easy, doesn't it?
Yes.
Just pause for a moment. Right, so to the west, running 2.
Yeah, to the west.
Oh, yes, I know that.
Yeah, to the west is Shands Road and south is Hamptons Road, both of which are natural boundaries for Prebbleton. The development history of Prebbleton involves extensive rural residential development in the western and southern areas. This form of development was not planned as such, and it significantly limits the potential for conversion of these areas to full residential, that we just discussed, Mr. Compton. To provide residential growth, and it has been necessary therefore to leapfrog these areas. Rural Residential Area 7 sits in the middle of proposed Plan 68, which I show in my evidence on page 3. This rural residential area was recognised in the Council's 2014 Rural Residential Strategy as needing to be future-proofed for residential density development, as it sits within the preferred urban form, and it assists in achieving long-term concentric urban form of the township and supporting growth west of Springs Road as far as Shands Road, rather than developing ribbon along the Springs Road. So that comes from the planning tribunal possibly, or Environment Court decisions on Stirling Park. There was a lot of discussion about where Prebbleton Grove, and they preferred it to be east-west rather than sprawling down Springs Road. So that's the reference there.
Somewhere there's a, I've seen the, not on this plan here, but where's that shown, there? Rural residential area 7 is shown on the plan somewhere.
Yes, it's on page 3 of my evidence.
Oh, whereabouts there? I've seen it somewhere. Sort of down the way.
It's an extremely odd shape.
But it's just basically a third of it, isn't it? It's right.
Yes, the rural residential sites that got chosen to be included in the rural residential strategy were a result of individuals asking for them to be so. So that's why it doesn't necessarily reflect the most logical planning boundary, but more people's property boundaries who asked. So we've got a dog in the
This is
shape.
what the council is saying there is this bit in the middle is going to be future-proof for more dense
Yes.
development, even though it wasn't at the time.
And that was the only rural residential block that's location that's in that strategy that actually has a future-proofing requirement.
Sorry, just pause there. That's in the strategy.
Yes. Which is essentially the
Could you
other.
make how big is this? I can't remember if I've got the strategy or not. Is it an enormous document or?
No, it's got appendices though, which is quite a few appendices, but it's actually quite a readable
Would you
document.
be able to make available to me the relevant part of it that relates to this, please?
Yes, no problem.
Not all of it, but it's not necessary. Yes, sorry, carry on, thank you.
The recognition of this as being potentially part of the township, that small area in the centre, has been carried through to the proposed district plan, which identifies this area as urban growth overlay. So the new plan has got an overlay which is actually not completely clear what its purpose is, but it certainly covers all the identified rural residential ones, as well as, yeah, I think that's pretty much that. Maybe the future urban development areas in the roster.
So where the tension here is between the fact that it's just the middle bit that's been done,
Yes.
and we're now looking at both the
Yes,
side,
yeah.
so that's the one I'm going to consider.
Yes, it's certainly quite an unusual decision from my perspective. Plan change 68 is sufficient area to enable higher densities to be provided at scale. The site can be serviced for residential development, utilising existing council plans to increase the number of water supply wells in the area and to upgrade the intersection of Trent and Shands, Hampton and Shands, Hampton and Springs, all of which will serve the development. The rezoning is consistent with the RMA and relevant national, regional and policy statements and plans as set out in detail in my evidence from 7.2 to 7.15. The outline development plan for the plan change contains the basic elements of the development area, including connections with adjoining areas. Two of these elements and their identification have been refined through the process of preparing the plan change request and responding to a 42A reports. These elements we've added the cycle routes, adjoining existing roads. It's a small matter really, they probably would have always had cycle routes, but we've now specifically listed those as occurring along the secondary and primary roads. And also what we refer to as frontage upgrades. This is added for the lengths of the plan change areas that join both Trent's and Hampton's Road. This notation requires developers of the plan change to upgrade these frontages to the usual urban standard, including wider carriageways, footpaths and cycleways. This will improve the safety and efficiency of the road with the increased traffic volumes generated by the plan change. This is something that many submitters requested, but what I understand actually has been a normal requirement of greenfield development. So the amended ODP with those two additions is attached to my evidence in chief. There are submissions from landowners within the wider Trent Springs, Hampton Shands block requesting their properties be rezoned. Some wish to have their same zoning as PC 68, that is living Z, while some others seek lots in the order of 5,000 square metres. The applicants who have owned a large proportion of the rural zoned land within the block are a group formed with common aim of a full residential zoning for their combined sites. They understand that they approached owners of the remaining properties to ascertain whether they wish to be involved in formally requesting residential rezoning. Some owners agreed and some others did not. Regarding the various requests, and I'm following here to a large extent responding to the section 42A report that goes through these rezoning additions. Rezoning of 5 properties fronting Trents Road between Stirling and Plain 60 area, that area referred to as the Gap, would enable the plan change to be fully integrated with Stirling Park, because the east side of that block become part of Plan Change 68. It would also avoid these lots being enclosed by residential development. Although, like Mr. Cleese wrote the 42A report, I do not consider this as a significant issue. I consider the rezoning request seeking subdivision size of the order of 5,000 square metres would be an inefficient use of this block, which is well suited for standard residential development. I also note that this would create the need for further leapfrogging should more residential rezoning in the area be required in the future.
Just pausing there, you heard my questions about the leapfrogging, and I think that the evidence we heard was, well, that was something which Scotland Mines said, this is something that was the case in the past, that used to be a principle, i.e. that you had a gradation.
Yes.
But he said that sort of basically went out the door.
Yes, I think it has.
In relatively recent times. Do you agree with that or not?
Yes, I do. I think it seemed like a good idea at the time, but it is a bit short-sighted because of growth. But it was kind of aided and abetted by the fact that the then regional policy statement defined rural residential as having to be not out of the residential area, but kind of close to the urban areas. And so it actually it almost encouraged this to happen. And it doesn't fit well when you want to try and do this kind of development close by and bring it, close to the town. So yes, it has. That was, I presume it's still the same rural residential criteria. It has to be not rural, but not residential. So therefore it gets stuck on the edge of the towns, and it has caused.
So rural residential had to be close to the town.
Yeah, that's what was required. And I think Prebbleton is probably an extremely good example of what not to do in that regard. It's just the word. It's meant a lot of good land hasn't been available for residential development.
You see, the reason I asked that is because in your paragraph 3.1 Roman 3, you said to revive the residential growth of initiative leapfrog these areas, and I didn't know whether you were saying that as a criticism or whether you just sort of.
Well, I'm just saying that we should learn from what's happened in the past. We've had to leapfrog. If we put more 500,000 on the edge of this one, some stage later, 20 years later, we might have to leapfrog it again. So, and Mr. Compton-Mohan talked about that.
So you agree with what Mr. Compton-Mohan said?
Yes, I do. Okay, 5C. I have no issues with the rezoning of 701 Shands Road, Mr. Shamey, as part of the Plan Change 68, again for the reasons Mr. Cleese has given. Is if you want the reference to the Rural Residential Development Policy in the CRPS, it's 6.3.9. That's the statement.
I have a copy of that.
Yep. I agree in terms of the section 42A report proposal for the 2 small areas that could be zoned consequential amendments. One of them is extremely small. It's a narrow site on 184 Hamptons Road. The other property is in the northeast corner of Shands and Hamptons. That's this property is owned by the council for roading purposes, and it would be used for the Shands Hamptons roundabout. That's why I believe it's been taken and its purpose is listed on the title as being for roading. So to me, it could or doesn't need to be zoned residential, but it could be.
I mean, when you look at them, they obviously are islands, so to speak, aren't they? But these two properties you're talking about, but how can it be said that they're consequential to this plan? In what way are they consequential?
Well, I suppose it's because one of them is such a small little slice of land that it's so small, sitting between large parts that are zoned, that it's, I guess in some ways it's almost the opposite, it's inconsequential.
So, I mean, if you're talking about, that's really a legal issue, I suppose, but talking about consequential amendments, you're avoiding the need to consider scope of submissions, whether it's within the scope of submissions, aren't you?
Yes, because
That's the advantage.
assuming that it's such a minor matter that it doesn't need to have a fully scope assessment, I suppose.
So in other words, what you're saying, that we don't really get that far because it can be treated as a consequential amendment.
Yes.
Okay.
Roading. Modelling by the Council's transportation consultant and by Mr Smith, who's just spoken to you, has been undertaken to enable assessment of the impact of traffic generated by Plan Change 68. This modelling was based on the already planned roading works in the area, namely new roundabouts at the intersection of Shands and Trents, Shands and Hamptons and Springs and Hamptons. The modelling has indicated periods when the level of service at Shands Trents intersection is particularly poor. That's the level of service D and E, which involves potential delays for motorists for periods up to 30 seconds. These lower levels of service generally occur in the morning peak. These poor levels of service can be overcome by increasing the capacity of the proposed roundabouts from single lane to dual or a combination of those options, which is what's been put forward for Shands and Trents. Mr Smith has modelled suggested changes of the Shands Trents roundabout and advised his support for their enhancement, which will deliver benefits for Plan Change 68 traffic, as well as wider benefits to existing and future road users in the vicinity of the site. On this basis, it's considered appropriate to stage the development, with the first stage of 120 lots becoming available after the construction of the Shands Trents roundabout, and the second stage, which is the remainder of the area, being available after the Shands Hamptons roundabout is constructed and the seal widening of Trents and Hamptons Road is completed. Now, I refer you there to 14.3 of my evidence where I've suggested the wording. It could well need refining, but that's, I'll discuss that. That's the top of that page.
Thank you.
It should have been in italics or something. It doesn't stand out. I've written that as if it would be, it could be put into this is, you know, the mechanics of the thing. You could put it in the ODP as a requirement. You could do belts and braces and put it in a subdivision. Some plans also put that into the land use, so no houses can be built, etc. So I mean, it's. But
what's your recommendation?
I think it should be in the ODP and the subdivision sections. So it's very clear to anybody who's proposing to do any development what is required in terms of staging.
At the appropriate. So what goes in the ODP?
There would be a statement about staging, and it could be the specific in terms of the 120 and then the remainder. Yeah. And it's quite clear. I mean, I think it should be done anyhow, but it also just gives the people who are concerned about this development that that's built in. It's not just hidden away in the subdivision section.
So where are we up to now?
Okay, density. The Christchurch City Council submission raises the matter of what is the appropriate minimum density required for this and other plan change areas, and requests that 15 households per hectare be adopted. I consider at this stage that 12 households per hectare proposed is an appropriate minimum, while acknowledging that applying a minimum density over a large area is a course control. This density approach will be refined in two main ways. Firstly, the actual design of the subdivision will provide opportunities to create discrete density areas. Secondly, since preparing my evidence, the Enabling Amendment Act has come in. This adds another dimension to consideration of density in residential zones. The Selwyn District Council has confirmed that before accepting any rezoning plan change, they will formally vary these plan changes to include the medium density provisions. In these circumstances, I consider that there's probably little point in refining the current Living Z rules for the Greenfield site, as it will soon be subject to a variation under this legislation. Despite the request by the City Council to adopt a minimum of 15 household per hectare, Mr Langman, in his evidence at paragraph 116, states that the higher densities may follow adoption of the MBR standards, raises significant issues in relation to infrastructure capacity and other effects that may potentially occur as a result of requested rezoning. So what I'm saying is there's been a request for increased density, but then there seems to be concern about increased density. This response raises several questions. Firstly, has there been a calculation of the potential difference between the 15 household hectares and the adoption of the MDR minimum density standards? The MDR provisions apply to existing sites with the aim to densify existing residential areas and thereby make better use of the land resource. It would seem likely that only a small proportion of new lots in the Plan Change 68 area would be purchased with the aim of having multiple houses on each lot. I suggest that the new MDR provisions are in fact unlikely to result in a density dissimilar to 15 households per hectare requested by the City Council. I suspect it will actually be less than that. If that is the case, then it's difficult to understand why the MDR provisions have been raised as an issue. Mr Williamson, in his paragraphs 64 and 65, referred to the Section 42A report approach to medium density provisions. He criticises the statement in the report that there is no guarantee that land will be developed to the full extent enabled by the medium density provisions. He then states it's entirely within the powers of the council, powers and function of the council to direct minimum densities, and in my view, to not do so is a contradiction to the purpose of the 2021 Amendment Act. The Amendment Act density standard in clause 10 of Schedule 3A states there must be no more than 3 residential units per site. In my opinion, this reads as a maximum, not a minimum density, and there's no specification in the Amendment Act as to what site size is required. I therefore agree with Mr Cleese that at this stage it cannot be assumed that the maximum density will occur even though it may be enabled. Okay, the NPS now on urban development. Mr Williamson's evidence does not assess Plan Change 68 against the NPS UD. This is surprising as it is a directive national planning document with the purpose of achieving well-functioning urban environments and planning decisions to improving housing affordability by supporting competitive land and development markets. It's therefore directly relevant to consideration of this plan change. In contrast, Mr Langman discusses the NPS and its relationship with the Canterbury Regional Policy Statement and other planning policy documents at length. His assessment addresses the implementation section of the NPS, which contains a list of what his council must do to give effect to the objectives and policies of the NPS. For plan changes providing for developments that are unanticipated or out of sequence and which provides for significant development capacity, councils must have particular regard to the development capacity provided by a plan change if that development capacity would contribute to a well-functioning environment and is well connected along transport corridors. Mr Langman concludes that while Plan Change 68 adds significant capacity for housing in the local context, that significant development capacity must be assessed in relation to the Greater Christchurch. In my opinion, that cannot be correct. as it would mean the only unanticipated plan changes that could be considered and accepted are ones that would provide for thousands of sections. Ignoring the fact that it's very unlikely that such a large area would exist or could easily be serviced, this restrictive approach would eliminate consideration of all areas which are logical and consolidated extensions of Christchurch or the townships and so on in one area. This is despite there being an urgent need to provide for more housing in all these areas. Another reason Mr. Langham gives for declining Plan Change 68 is that the cumulative effects of proposed greenfield expansions would likely compromise opportunities for intensification elsewhere in Greater Christchurch and impact on servicing. He also refers to a spatial planning exercise that's been carried on by the Great Christchurch Partnership, and that approving Plan Change 68 would compromise future options for greenfield development. I consider these statements to be overgeneralisations. I cannot see how enabling development in this part of Prebbleton would impact on servicing elsewhere. If the spatial planning exercise adopts sound planning criteria for identifying growth areas, I'm sure it would conclude that Plan Change 68 is well located to provide for the growth of Prebbleton. The third matter I wish to comment on is the relationship between the NPS and the Canterbury Regional Policy Statement. Chapter 6 of the CRPS sets out a framework for recovery from the earthquakes. Objective 6.2.1 contains a series of criteria for the location of greenfield areas, including protection of outstanding landscapes, maintaining water quality, integration of infrastructure with land development, and protection from natural hazards. Plan Change 68 generally satisfies these matters. The one requirement it does not satisfy is it does not fall within the identified greenfield priority area or future development area in Map A, referred to in Chapter 6. This is not surprising as the extent of growth demand for housing was not anticipated by most planning documents associated with the Greater Christchurch area. This very situation has been recognised by the NPSUD, which provides for a responsive planning approach for consideration of plan changes that are not provided for in current planning documents, in particular in clause 3.8.
Just pause there with you. I think what's being suggested is that, and this is what I'm having trouble with at the moment, is that the Regional Policy Statement Change 1 was approved and became operative on the 28th of July 2021 after the consultation process. I mean, wouldn't it have, and my understanding also is that it suggested that that did respond to this document, namely the National Policy Statement.
Yes.
Well, now, did they get it? I mean, I appreciate the evidence that's been given us, the cells, etc., is that without any doubt at all, there's a huge demand and there's no supply.
Yes.
But the point is that what the opponents to the change are saying is, look, this has already been looked at. It was looked at very thoroughly. It was looked at after the policy came into force by the Greater Council of Christchurch members, so to speak, and it turned up with proposed change number 1, which resulted in map A.
Okay, I'm quite happy to talk to that because I'm reasonably familiar with it, and it's been discussed at a recent hearing of the proposed cell and district plan, where these same thoughts have been put forward to some rezonings or the strategic direction. As I understand it, the timing of the change 1, when it first became prepared, the NPS wasn't, hadn't come into effect. There was quite a lengthy process when they did consult and when they had to get the minister's approval. The NPS came in, they then finalised the plan change, and it did not change at all. So it was actually prepared without the NPS being in effect. So without wanting to be sort of, what's the word, too-pointed,
I think
the timing is such that I don't think they did take the NPS into account. I mean, sorry, they did nothing. They changed nothing as a result of it.
Well, I think this could be quite important because there's a very very important argument on the other side. They're saying, look, you know, you're not really in a position to be considering this because it's already been considered. And if they were right, then it would tend to reinforce the sanctity, so to speak, of map A. Now, just pausing there, what you're saying, I've got it right. You know, the last couple of days did a bit of a diagram here with all the dates on it. So the Greater Christchurch Strategic Framework, I've got 20th of August 2020, so in other words that they were working on it then. The National Policy Statement on Urban Development, sorry, I got wrong. Sorry, forget about that. That was 2019, and they came up with a document called Our Spaces 2018/2048 Greater Christchurch Settlement Pattern Update. So I understand it. I understand that was about 2019. So then you get down to the National Policy Statement on 20th of August 2020, and then, as I said before, the change one becoming operative on the 28th of July 2021. Now, I understand what you're saying. You're saying, notwithstanding that progression of time that I've just outlined, in fact, it wasn't taken into account because nothing changed.
Yeah.
Is there any other evidence of that? I mean, can we look, is there some discussion documents or surely there'd be something underpinning our spaces which would indicate whether they did take into account?
I'm not aware of anything, but I certainly couldn't say that I know everything about the background to this. I'm not aware of anything that was written. The section 32 and the minister's response are fairly generic.
Well, is the point then that as far as you're concerned, you think that the evidence that they didn't take that into account is that map A didn't change?
Well, map A changed as a result of change one, but it only changed in a limited way, and that was already underway before the NPS came in.
Before the NPS came in, you say?
So it did not appear to change as a result. And I guess the other aspect of it, even if it did, to me, it clearly hadn't looked very carefully at what actual demand was, you know, what needed to be addressed.
So could I sort of interject? So change one commenced under a prior national policy statement, which is the national policy statement of 2016.
No, but what I'm saying, on my schedule here, by the time the change came into force, the new national policy statement, the one we're talking about now, the urban development one, had come into force on the 20th of August 2020. And then after that, you've got the change one becoming operative, having been approved by the minister on the 28th of May 2021, which is about 8 months after, or more than 8 months, you know, it's, or say 8 months after the national policy statement came into force.
So my understanding too is that the areas identified, the future development areas identified, were first identified under the 2016 version as a response to the 2016 NPS. I think what Ms. Hart is saying is that no further analysis was required.
No, I see.
Considering the additional areas to meet the 2020 version.
Is the earlier one 2016?
Yes, National Policy Statement for Urban Development Capacity.
Well, can I just say this, that could be quite important, and what I would like, and I would ask you to put that to me, if you've got it, any documentary information which suggests that in fact, when change one was promulgated, that it was only reacting to the 2016 document as opposed to the later one.
It initially, as I said, the areas were initially identified under the 2016 version.
Yeah.
You will look at you will look in the appendices to the report for the 2021 version, and there is an assessment against the latest national policy statement. So those are the appendices I sort of referred to earlier, if you recall, sir. And it has that discussion.
So you say there was, they then tested it against the later one?
It was analysed against, there was a section 32 analysis for a start, which analysed
Against the latest.
the document that had been commenced, initiated under the area NPS. There is I think there's a section 32 analysis. There are a couple of appendices to the report to the Minister which refer to the 2020 NPS. I'm unsure, sir, whether or not anything that sort of includes an analysis or whether there's any requirement to update the analysis as to capacity, demand, and supply, etc.
Well, I think it's important that we, I get us on this because, so what you're saying is that the 2016 regional policy statement, national policy statement, was the springboard for the first analysis, which, and then they worked out how Map A was going to look. And then when the next national policy statement came out, they tested it against that, but didn't actually make any changes.
It really didn't make any changes.
Yeah, okay. And I know the argument about, well, they should have taken into account Prebbleton, etc. I understand all that, but that's surprising, isn't it? That if they did actually, if the national policy statement came out, that they didn't have a jolly good look at it and say, well, we better have a look at Map A again. That's what's worrying me.
So that's a question, of course, for the regional council.
Yeah. Thank you for that. That's very helpful. Thank you. Just to make a note. You're quite right. All right. Now, sorry, I'm interrupting you. Where are we up to?
Yeah, I'm not, yeah,
Implementation.
sure. I've been turning over some pages, so I'm not completely sure.
No, I think we're up 7.6, I think.
Okay. Mr. Langman provides a lengthy discussion on this matter, in which I understand him to say that the prescriptive requirements in the regional policy statement, such as avoiding new developments outside greenfield priorities and Map A, must still be adhered to, despite the fact that the NPSUD, which is a national planning document, requires a responsive planning approach. I agree with Mr. Langman that plan changes for unanticipated greenfield development must be fully scrutinised and not automatically approved. However, in my mind, the difficult situation that has arisen with growth demand and needs occurring at an unanticipated rate is acknowledged and provided for in the NPSUD. It enables rezoning proposals to be assessed against specific criteria and their general merits. To still require developers to meet the requirements of Map A in the CRPS, regardless of their merits, would be to negate the ability to be responsive. Implementation processes. Mr. Williamson has raised several issues relating to how plan changes can or will be implemented. In particular, he queries whether services can be provided, how the matters listed in the ODP text or narrative can be implemented, and how funding for servicing can be achieved. But much of this has already been covered, but I'll read it anyhow. He also questions how urban design elements referred to in evidence and in the ODP can be implemented. Specifically, he considers that the plan change should include provision for financial contributions to achieve various elements of the development, some of which are covered in the summary evidence of Mr. Hall. While I'm not directly involved in all post-zoning processes associated with greenfield residential development, I am familiar with various development contributions regimes and with the working relationships that are part of the development process. Based on this understanding, I do not share Mr. Williamson's apparent concerns that things will go wrong. Firstly, the applicants are all experienced local residential developers and are so fully aware of the processes that need to be gone through. They are also familiar with the subdivision process, which sets out through conditions all their obligations relating to installation of services at their cost, as well as development contributions set out in the Council's policy. In addition, the policy specifically provides for developer agreements for additional works where the applicants part funding works which also benefit the community. Mr. Williamson has also raised concerns about how the ODP in this text can be implemented. The approach of the plan to date has involved a requirement in the subdivision section that subdivision applications are to be in accordance with the ODP for each of these areas. If a subdivision is not in compliance, it becomes discretionary and non-compliant in some matters. In addition, the text of the ODP gets inserted into the district plan as a policy, thereby doubly ensuring all important matters are considered at the subdivision stage. This approach has worked for many years. And I've just listed there regarding the specific matter of the adjoining roundabouts needing to be constructed prior to stages. I've addressed this in 14.3 of my evidence. And I've listed that there. I state that this provision could be included in the ODP text or the district plan subdivision provisions. Alternative wording may be possible. For example, there could be land use control on the staging of houses being built or residential activity occurring. Zoning. I note that the section 42A report refers to Plan Change 68 requesting rezoning of most of the site as living Z with a strip of low density living X zoning minimum of 1,500 square metres along the Shands Road frontage. Just for the record, the living Z zoning was requested for the whole of the site, but with a requirement in the ODP that the land fronting Shands should have a minimum lot size of 1,500. Reverse sensitivity. While there is a potential for reverse sensitivity effects to arise when residential development moves into an area where farming and other productive activities are currently carried out, I consider that these are unlikely in this plan change area. This is due firstly to there being no current activities such as those mentioned in the 42A report, such as intensive pig farming and dairy sheds and the like. The parts of the landscaping business that on the corner of Shands and Springs, which adjoin plan change area, appear to be pasture and nursery trees and shelter belts, with the working area further west. The nursery business at 382 Trents Road appears to have been mostly of its operations within glasshouses. Secondly, the design of the development can accommodate larger section sizes to enable greater distance between these sites and new housing if that's considered appropriate. And that's the flexibility you get with having a general density requirement. You can have make up for a large site with a number of smaller sites. Greenhouse gas. Mr. Langland refers to the lack of assessment of the plan change regarding it being a well-functioning urban environment as defined in policy 1 of the NPS. In particular, he queries whether the plan change will support reductions in greenhouse gas emissions. I understand that transport emissions are a significant ongoing generator of greenhouse gas associated with residential areas. Mr. Smith's evidence considers sustainability of the plan change in detail at paragraphs 12, 23 to 33 and concludes that the site is 16 kilometres from Christchurch Central City, which is closer than all other satellite towns and is comparable, in many cases, less than travel within the city boundary. I've also noted in my evidence that some of the main employment areas such as Stockburn and Wigram, that would have Stockburn basically being hauled there as Stockburn, are very close to Prebbleton in terms of commuting. While the plan change site is not well served by public transport, there is a real potential to improve the public transport provision to better connect the site with Christchurch and Lincoln. The site is well connected for walking and cycling to the Prebbleton town centre, including a supermarket and a new commercial centre, school and key destinations within Prebbleton. In addition, changes in transport modes provide for more flexible options, making what was a car trip now feasible on electric bike and scooter that should probably be in there. Plan Change 68 area will be provided with fibre, which will enable working from home opportunities, which of course is increasingly common. Regarding the comparison of Plan Change 68 with intensification of existing residential areas, the National Policy Statement contemplates expansion as well as intensification. Therefore, in my opinion, it's not appropriate to compare the two forms of increasing capacity in the context of supporting a reduction in greenhouse gas emissions. Regarding the Regional Policy Statement and greenhouse gas emissions, Objective 6.2.2 supports consolidation of urban areas. This is a key objective of the policy statement. The explanation for this objective specifically states that a key reason for promoting or requiring consolidation is that this form of development is the most likely to minimise the adverse effects for work and education, business and recreation. It is perhaps surprising then that the latest and only amendment to the Regional Policy Statement for Greenfield Development, that is Change 1, was the addition of 2 future development areas at Rolleston, which are 21.7 to 27.4 kilometres from the central city, as compared to Plan Change 68. Which is only 16. I agree with the conclusions in the 42-hour report of Mr. Cleese and his recommendation that plan change is to be granted. In particular, I agree that it will promote the social and economic well-being of current and future residents of Prebbleton and potentially Greater Christchurch by providing more land for residential development. It gives effect to the National Policy Statement on Urban Development 2020 and is the most efficient method of promptly achieving the outcome of additional land for residential development in Prebbleton.
Thank you. I've answered most of the question on the way through, as you probably would realise. You heard my discussion with Mr. Cleary about what seemed to me to be an unusual process associated with the variation report. You know what I'm talking about. So the variation report said, well, look, we'll take it. We won't go as far as clause 17 of the first schedule, but as Mr. Cleary made clear this morning, what's intended is that should I approve or recommend approval of the change, the council will then consider whether to accept my recommendation, and it may accept it without approving the change in terms of clause 17. It would then incorporate the change into, well, this is a question, of course, there's a question about how do you get the change then into the variation, and I think someone from the regional council said, well, you can only way you can do that is someone would have to make a submission that the change then be, but there may be another way. I don't really want to debate that now. I see Mr. Cleary shaking his head, and he may have reasons for that. But anyway, that's not something I'm really, assuming that the council is intending that the change then become part of the variation, and then so it'll have part of the variation dealing with the new enabling act, the 3-story act, if we can call it that, and then the other part will deal with this change that it goes forward, and then it's public notified and everyone has another shot. It does. I struggle with that a bit as to.
I think that's a simple version of it too. There's a number of other possibilities because the council might choose to use that opportunity to rearrange the sort of zoning types, etc. I mean, it seems to me there's almost I'm not clear to what extent they're altering the ODI, the current plan, to the new plan. It's just the way I've read, but I have only read the document once.
Well,
say, I just find it, it's confusing.
I think this may need some further submissions, but it seems to me that it's rather, if I may be blunt, watering down my role to being a role where in reality what I'm doing is recommending that something be included in a variation as opposed to approving a change. Now, I know I am being asked to approve the change, but because there's going to be another bite at the cherry, so to speak, and everyone else is going to have another opportunity to say they don't like it. It does seem rather strange.
And it's very odd, it's very unusual, but I think if it's just if you take it at its sort of most obvious level that they want to give consideration of MDR provisions, and I suppose whether there should be any exemptions or something, I forget the word that they use. This seems to be the only way that they're thinking they can do it, and they'll be dealing with all the plan changes.
Well,
so it does get it down, I suppose, in terms of these current plan changes, and it certainly is going to delay the whole process, which is very frustrating for everybody. What else will go on? I don't know.
Well, I think the point about that is that when you read the variation report, it's called the variation report, which is what it is. It's clear that what they had in mind was that if they approved, so say I made a recommendation and that was approved by the council under clause 17 and became operative, that would derail the variation process, so to speak, which is the Enabling Act variation process. Because and then they'll be open to criticism. It's not for me, I'll make it quite clear, I am not proposing to.
No, I do think the question about your role, I think it's very, very important. It's pivotal that you provide them with a very good response to this plan change, and that should create a very good baseline for whatever else they're going to do. So
Well,
I
I
don't think this is unimportant. I think this is very important hearing and decision and recommendation.
Of course, I'm going to do my best, and of course, I'm going to look at things very carefully and take this very seriously. I mean, nothing I've said should indicate just because it's going to be another bite of the cherry doesn't mean to say I'm going to be less careful than I would otherwise be. Of course, that's just nonsense. But I think the answer really is that I will do this, and that the comments I've made about what the effect of it may be really is not a matter for me. It really isn't. It's a matter for someone else, not for me.
Somebody this morning explaining the process, I'm not sure who it was, that she said that once they accept your recommendation, that it then gets notified and such that people, no, that it actually gets, people can appeal at that stage now.
That surprised me a bit, because what would be the point in appealing then if you don't know what the final outcome's going to be?
Well,
I don't know.
Because it's just a one component of it, maybe, I don't know.
That again, that's not a matter for me, and I'll make
No.
that really clear. I mean, it's entirely.
No, so, but it might mean that the matters considered today and tomorrow and next day, will actually have their chance of going through the process fully in terms of appeals. And so that gets sorted, and then the variation happens before it's actually made fully operative.
Well, I'll certainly be putting that to tomorrow to Mr. Langman and Mr. Wakefield.
Yes.
I think it will be important to listen with interest as to what their sort of position is in relation to it. Well, I think we've probably reached the end of the day.
I should say, sir, I'm shaking my head at the submission, and that's Mr. Williams. Evidence as opposed to anything you guys said.
Well, so I think we're at the point now where, and I take it nobody wants to. I'll just before I make the direction, I'll ask anyone that's not happy about it. But so tomorrow we will be hearing Mr. Shammy and Mr. Wakefield and Mr. Lang, and that'll be followed then by hopefully the accelerated the Chen, Fletcher, Bowman, Burgess, Phillips. So that, assuming that they're available, they'll fit in the slot where Mr. Williamson and the others would be. Mr. Williamson and the Summerfield group will then be shifted to Monday morning, and they'll be followed. My view is that we shouldn't have the reports from the council until everything's been given, because I want them to be able to be responding to all of the evidence. So having them before that seems to me to be the wrong way around to go about it. So what I would intend to direct is that they will follow on Monday. So we'll have a pretty full day on Monday, because we'll have Mr. Williamson and Summerfield and others, all those submitters, and then followed by the England columns and the. Has anyone unhappy about that? Does it affect anyone's ability to turn up or whatever?
Sorry, just back to what you asked me to. I didn't take a note of from the first thing you asked me to give was some information on the rural residential strategy, and the second one was to do with the RP.
RPS, I think
that history of RPS.
Yeah, just give me. Actually, I'd quite like a hard copy of the RPS. Not that long, but. That's right. You're fine.
But you only need chapter 6 and possibly chapter 5.
Yeah.
So that's doable. Yeah.
All right. Thank you. Thank you for that. It's been most helpful. Now, so I'll adjourn the hearing now until 9 o'clock tomorrow morning, at which time we're going to hear from Mr. Shammy, followed by Mr. Wakefield and Mr. Lang. All right. Thank you for your attendance. Any questions about anything? Or
Pretty good. Just on tomorrow's schedule, and then we're missing from sort of 10:50 through till.
well, I think yes. So I would think that Wakefield and Langman, they're on at 9:30. Mr. Shammy may take longer than 30 minutes because there are some quite difficult legal issues about scope, etc. I need to cover with them. I'm not sure he's been represented on this.
Yes, he is by Wastewater.
Oh, yes, so that could take an hour, and then that's followed by Wakefield and Langman. So I would have thought that Mr. Chen would be on at about 11-ish probably. Followed by the others as that. And we just keep going until we finish them.
Yeah, okay. So
Is that right?
yes, so someone can notify the other parties later in the day to come to it.
Well, like that, yeah.
Okay, cool.
Yes, everyone, I want everyone to be absolutely clear as to, so that they know when they can turn up, and I want to make sure that there's no, that everyone's got the ability to be part of the hearing all the way through, even though we're having to change it around a bit because of these situations. All right?
Sounds good.
Well, I'll see you all tomorrow morning at 9 o'clock. Thank you.